Okay. If we are content, are you happy for us to proceed to the agenda? Agreed. Apologies. I've had apologies from Jim Wells. Any other apologies? None received. Has any member received authority to delegate authority to another member of the committee to vote under Temporary Standing Order 115? Nope. Declaration of interests. All members are pledged to declare any relevant financial or interest at the committee meeting as applicable. I declare an interest that I know Professor Hayward, David Henning, Christian Benson and Shankar Singham from other events that I've been at and other conferences that I have been a member of. Any other declaration? Oh, and I was involved in, I still am involved in a court case to do with the protocol.
Me too.
As is, I note, as Mr. Allister. Any other declarations of interest?
Nope.
Okay. Thank you. Moving on to the next item of the agenda, Chairperson's business, June monitoring. The Minister's June monitoring round statement included a number of very welcome allocations to communities, health, education and justice. The statement also referred to a number of changes to the capital programme, including a reduction in financial transactions capital and reinvestment and reform initiative borrowing. It is hoped that the Executive will be able to use capital investment to reinvigorate our post-COVID economy. It is therefore worrying that this early in the year we're already seeing uncertainty and apparent softening of that capital programme. Members, are we content to write to the Department and seek clarity as to whether there is a problem with the delivery of capital programmes in the construction sector, or whether there is a problem with sufficient officials in the Northern Ireland Civil Service to manage the capital programme? Even at this stage of the year, it seems strange that it is quite a lot of softening up going up. Hi Gemma, good to see you. Are we content to write to the Department? Agreed?
Yep.
Next item is the Northern Ireland Affairs Committee Northern Ireland Protocol meeting. The Northern Ireland Affairs Committee has invited me to chair its next informal meeting with the statutory committee chairpersons on the Northern Ireland Protocol on the 7th of July. Are you content to note? So noted. The draft minutes of proceedings on the 23rd of June. The draft minutes of the Finance Committee meeting on the 23rd of June at page 7. Are members content with the draft minutes on the 23rd of June or an accurate record of proceedings? Are we agreed? Agreed. Thank you. There are no matters arising. Okay. Right. I'd like to bring into the spotlight, I would like to bring in Professor Katie Hayward, Martin Howe, QC, Dr. Anna Jazeski and David Henning, Director of UK Trade Policy Project. Could we bring all four into the spotlight, please? Hi Katie, hi Anna, hi David. Do we...
Hi.
Have we got Martin?
I'm here.
Martin, are you? Oh, excellent. Good to hear and see you again. Sorry about that. Sorry, we didn't get that this Western. Team, we're taking evidence on the Northern Ireland Protocol, which is obviously of quite of considerable interest, and we're receiving oral evidence from experts in a range of fields to advise on different areas impacted by the Northern Ireland Protocol. We're welcoming Professor Katie Hayward, Professor of Political Sociology, Queen's University, Belfast, and she'll address a wide range of issues with members including the sea border, public opinion, and has highlighted the area of scrutiny of governance in her written submission. Martin will be bringing legal expertise to the committee's discussion on the protocol and the UK Internal Market Act. Anna will be, as a customs expert specialising in the movement of goods, who can advise the committee on experience on the ground. And David is going to bring us focus on the issues of good regulations and checks. For the committee, the following papers are relevant. The Clerk's briefing paper, it's page 16. A briefing paper from David is on page 18. An IFG report on the UK Internal Market Act is on page 19. And papers from Katie and Martin are in tabled items. I would like to remind you that the session has been recorded by Hansard. I'm going to ask each of you to make an opening statement for about 5 to 10 minutes, and then we'll come back to questions from the group, as the rest of it as well. Just to inform you, we've had quite a lot of information so far about the protocol, so feel free that you don't have to. What would seem to be some of the more arcane things, if you just feel as if you're happy to talk about them as you go through. And I think most of us are now sort of fairly up to speed in sort of the minutiae. And I say now that there will probably be quite a few questions on the minutiae as we go through and the rest of it. But Professor Haywood, and it gives me an enormous amount of pleasure to actually use that official designation on a committee. But please make your opening remarks.
Thank you very much, Chair. It's a great pleasure to appear before you this afternoon. So I will just make very brief remarks. As you may be aware, we have just published today the latest findings from a poll that was conducted by Lucid Talk on our behalf in Queen's. And I'm happy to discuss some of the details of those in due course. But for my opening remarks, I just wanted to sort of put things in context, really. And this is basically to say that the current situation with respect to the protocol is really quite entirely predictable in many ways. I was looking earlier at a piece that I wrote with Tony Smith, who's the former head of the UK Border Force. We published this in May last year on the LSE blog, and we were advising on what needs to be done in order to minimise the disruption associated with the protocol, bearing in mind its implications for movement of goods across the Irish Sea. And we asked for 3 principles to be borne in mind and acted upon. The first was the principle of partnership, recognising that implementing any border or change in border management system requires a wide spectrum of actors to be involved. It requires care and caution with respect to the design of the system used to manage that border, and importantly involves trust and respect between government agencies and industry, i.e. those tasked with using this system, bearing in mind, of course, that COVID complicated the conditions within which this border management system was going to be developed, the new arrangements were going to be enacted. We can still recognise that there were serious failures with respect to partnership, as we would have hoped to have been seeing in 2020. Another principle we talked about was cross-border cooperation, the need for collaboration and good communication between those involved. In the protocol case, we have an unusual situation, of course, in that the UK authorities are the ones implementing the EU's border, so to speak. But we do know that collaboration and communication has been essential between the UK and the EU is severely lacking, particularly with respect to transfer of relevant information. And just on that last principle, the principle of preparation, part of the preparation that was needed was adequate access to relevant information. That was not present at the time, and there is still a long way to go until there is adequate information on the movement of goods across the Irish Sea to enable intelligence to be used and to minimise the checks happening. So in practice, none of those principles were enacted, despite my best efforts with Tony Smith and others appearing before you as witnesses. And of course, the practical implementation of the protocol and preparation for its implementation was caught up very much in the political negotiations last year. The use of the UK Internal Market Bill and certain clauses in that added to the political pressure and indeed distracted from the requirements of the protocol and the necessary preparation for implementing it. So by the time we had those decisions in the 17th of December, they were temporary measures. They weren't what was being asked for by business from Northern Ireland, not least of which was the need for certain mitigations and also a clear amount of information in advancing preparation for the protocol. So by the time it came to it, we had not just the disruption and the paperwork burden, which is definitely the most consequential impact of the protocol so far on businesses. There was also that context of uncertainty. We've seen good movements today with the announcement of extending that grace period on chilled meats, but in many ways that just adds to uncertainty in some ways because it's not any long-term resolution. With respect to the long-term resolution of these major issues, i.e. SPS controls, this is an ideologically significant decision. So in effect, it's only significant because the UK government decided that what it is currently not prepared to do for GB, i.e. align dynamically with EU rules, it was prepared to allow to happen for Northern Ireland. And all of the discussion around the veterinary agreement, etc., comes in that context. And just to conclude, this is now, of course, therefore, inevitably a wider concern for politics in Northern Ireland and a wider concern for society. And we're seeing that in these latest results from this Lucid Talk Queen's poll. Notably, the majority of concerns lie with respect to political stability and governance and scrutiny of decision-making around the protocol. And just to conclude, we did see a good step in that direction earlier this week in the Assembly, with Shevkovich appearing before the Committee of the Executive Office. I know Lord Frost has been extended an invitation as well. I hope he takes that up because a clear majority of our respondents were suggesting that they would like to see such accountability and scrutiny in practice. Thank you.
Thanks, Kitty. Just before I bring in Martin, the Lucid Talk poll, what was the margin of error on the Lucid Talk poll?
It's plus or minus 2%, 2.5%.
And the sample size?
So the sample size that was used for the weighted analysis was 1,500.
Thanks. Okay, thanks, Kitty. Martin?
Thank you, Chairman. Can I just say that my focus is on the, in effect, the legal and constitutional aspects of the protocol and the way it works. And I've sought to summarise that in a short paper, which I produced, and I apologise for the late stage of it. But the main point in that paper is that the legal status of the protocol, the status that it has been given by the Act of the UK Parliament which implemented it, namely the European Union Withdrawal Agreement Act of 2020, is actually akin to the legal status that was given to the European treaties and to instruments underneath them, European Union secondary legislation and laws, during our period of membership of the European Union. And the consequence of that is that all the same doctrines, supremacy of EU law, and the fact that EU law will override all laws of national origin, continue to apply within the scope of the protocol. And particularly they apply within Northern Ireland, although in the case of the state aid provisions, there's an overreach to the whole of Great Britain. The consequence of that is that although the UK Internal Market Bill can be regarded as providing modern-day implementation of the principles that were originally put into the Articles of Union of 1800, and indeed in the earlier Articles of Union between England and Scotland, for the free movement of goods throughout the United Kingdom, without being held up by barriers between different parts of the United Kingdom or different legislative provisions. Unfortunately, the legal position, as I analyse it, is that the protocol prevails over, and indeed it contradicts and prevails over the principles in the UK Internal Market Act, even though that act is later in time than the Withdrawal Agreement Act. And that is by application of the quite an old case, but very well-known principle in the Factortaken case, where it was held that an act of the UK Parliament was overridden and had to be rendered ineffective within the UK courts as a consequence of a conflict with provisions of the then Treaty of Rome, in fact in the context of fishing and quota hopping that case was. And this applies. So we have a scenario where the protocol itself is a sort of superior form of law to acts of the UK Parliament or indeed assembly measures, and will override them. And indeed any secondary European Union measures which are given force within Northern Ireland by the protocol will also override domestic law. And this problem, the question of checks at the Irish Sea border, of course, is very, very important. And the adverse impact on businesses in Northern Ireland of checks is obviously very much in the public spotlight. However, in my view, that's not really the fundamental source of the problem. The fundamental source of the problem is that Northern Ireland is obliged to accept different laws from those applying in the rest of the United Kingdom, with no possibility, as long as the protocol remains in anything like its present form, of those laws being adapted or altered or opted out of. And this means that as time goes on, and as inevitably divergences will occur, and more divergences between European Union laws and laws of the United Kingdom, Northern Ireland will be left stuck without any choice in the matter within the EU system. And one particular example I've given where this is particularly important, I think, at the moment we're talking about chilled meats and sausages and things, and unfortunately, as serious as it is, there's a sort of slightly comic potential in that, harking back to the Yes Minister series and the speech about the EU's European Union sausage directives. But it is serious enough, but the more fundamental problem can be exhibited or explained by the example of medicines regulation, where one aspect of the protocol is to import into Northern Ireland European Union medicines laws, the regulation which governs centrally granted marketing authorisations granted by the EMA, and the directive which regulates the conduct of national authorities within the member states, and in respect of Northern Ireland, binds the actions of the MHRA. And the consequence of that will be that as time goes on, that there will increasingly be cases of medicines, and sometimes important medicines, which will be licensed for use in the United Kingdom, but will not be available within Northern Ireland because of conflict with the European Union medicine system. I think I'm producing that really as an example, because you could make similar points, although perhaps not with such serious consequences, across the board of the huge area of European Union laws which are applied to Northern Ireland by this protocol. So my conclusion, I think, is that the problems with the protocol are real democratic and constitutional problems, which are so fundamental that whatever you do to try and ease up border controls are not going to be solved, and therefore something more radical will have to be done with the protocol.
Okay. Thank you, Martin. Anna?
Thank you very much. I'd like to use these opening remarks to provide a bit of an overview of where we are in terms of customs and the border, the impact on traders, and why this is still very much a moving picture, why this is still subject to change. This will be very high level, so obviously I'm more than happy to discuss these points in detail when we get to questions. In terms of the protocol, we know that it was a high-level agreement, and it was quite obvious from the beginning that it will be all around how this is implemented. And when it comes to customs and movement of goods, that area that I work in, it was Article 5 and the implementation of Article 5, which was left to the Joint Committee, and the crucial decisions around Article 5 were postponed to the second half or the final quarter of 2020. So where we ended up in January was a solution, a multi-layered solution that allowed various ways for traders, NI traders, to avoid paying EU tariffs. You have the end-use option with the trader scheme, you have the option based on tariffs, and you have the waiver. So 3 ways to avoid paying tariffs. And that system is incredibly complex. It used to take me about 7 to 10 minutes to provide a very brief, high-level overview of this solution to companies, and very often it was not sufficient for them to understand what they need to do. At the same time, and I think it's important to point that out, if you just look at how similar situations, and I don't mean a similar situation as such a unique border as the one that we have now, but questions around goods arriving at the border without certainty what's going to happen with them later on, such situations are normally addressed by customs by options or solutions that are much more burdensome in terms of additional admin for companies. So in a way, and I appreciate it might sound like a contradiction because it is a complex solution, but in a way, it is also pragmatic and flexible and provides various options for companies to avoid paying tariffs. I think it's quite important to mention that. The second point would be that this is very much still subject to change. So since January, we've had some clarifications, some guidance, some changes that were incredibly helpful, like the apportionment system, which means that if you are a trader, if you are a UK, if you're under the trader system, you can tell customs, look, 80% of these goods are going to stay in NI and 20% might enter the EU market. This is a helpful simplification. But we're also going to have some changes that might impact how companies operate at the moment. So for example, the trader scheme at the moment is opened also to companies that are not established in NI from November onwards. This will be narrowed down to companies that are established in NI. And it might sound like something that's beneficial for NI companies, but under some scenarios and under certain circumstances, this will actually be more difficult for NI companies, and I'm happy to come back to this.
Anna, can I just ask a quick question there? Sorry, just to get this clear in mind, it is only companies that are registered in Northern Ireland, or is it companies have primarily their business based in Northern Ireland? Because obviously an awful lot of Northern Ireland companies are registered in GB.
Yes, so there's a entire guidance on this. It's obviously companies that are established in NI and companies that have their principal operations and customs operations in NI. Right. So it's not just simply companies that are established. This is the first condition. Then there's an option for companies that are not established, but are also supplying NI clients, companies that are established and have the principal customs functions in NI, and so on and so forth. There are other conditions. So there are several conditions. From November onwards, this will be narrowed down to companies that are either established or meet the, I've forgotten the actual term of it, but meet the principal operations in NI criteria. So there's again a set of criteria that companies need to meet before November in order to be to continue to be eligible to take advantage of the trader scheme.
Okay, thanks.
And so that's one of the changes that is upcoming, and every change obviously potentially brings additional disruptions, additional confusion. The IT system that NI companies use to trade with the rest of the world was supposed to change this month. We're not entirely sure when this is going to happen, but it again is another change. And I think one of the most important aspects here is the fact that the definition of unfettered access will be narrowed down. So this obviously is one of the key parts of the protocol, the unfettered access from NI to GB. Yet we've known for the last 6 months that at some point this year, we will get an updated definition of who can benefit from this unfettered access. And the point here is to make sure that it's only NI companies or companies located in NI that can benefit, to prevent a scenario whereby, for example, a German company imports something, or not imports, moves something to the Republic, from the Republic to NI, from NI to GB to avoid customs formalities and tariffs if tariffs are due. But again, depending on how this is done, it might again have a significant impact on some of the companies located in an eye. And just finally, around impact on traders and impact on trade.
Just going to ask you just a quick question here, because again, that's an important point about the issue about unfettered access being narrowed down. For example, the likes of Tesco's and Sainsbury's, who have, or particularly Sainsbury's, which has a large distribution system coming into Northern Ireland, but only deals within Northern Ireland, but is obviously not a Northern Ireland company by any shape or form. Does that mean, therefore, that the definition that wouldn't apply to them?
We don't know yet. We don't have that definition. We don't have any visibility of how this is shaping up. We've known because there is a sentence or two sentences in one of the HMRC guidance saying that at some point in 2021, we will get a proper definition of which companies are eligible. We've heard that this is to make sure that it's only companies located or working in Northern Ireland, but we don't have visibility of what this is going to look like. I would imagine that companies like that will obviously be taken into account, but this is just an opinion at this point.
Okay, thanks.
Okay, so to just kind of finish off the opening remarks, in terms of impact on trader, I think what Martin mentioned about checks is incredibly important, but I think it's also important to remember that checks very often, especially when it comes to customs, perhaps slightly differently for SPS issues, checks are not where the problem or the main problem is. It's the work that companies need to do before the goods arrive at the border or afterwards. So it's the formalities, it's the work, the additional compliance, the additional knowledge that companies need to have to be able to get to that border. So many solutions that are proposed to quote, solve the border issue focus on like the mutual enforcement, force on the removal of checks. But checks are not the only problem, and they completely forget about the how much work is involved in the formalities. So I'm happy to continue talking about it or trade the version that occurred and that we've seen with companies as well, but I think I'll stop here for now.
Okay, thanks, Anna. Thank you very much indeed. And sorry for interrupting as we went through. There were just a couple of important points there I just wanted to bring out while I was fresh on them. David, over to you.
Thank you very much, Chair. Another occasion when I would like to be with you in Northern Ireland, but can't be. Hopeful to join you soon. Look, I want to make 5 brief points, I hope, that explain my point of view on the protocol. The first one is that modern business and trade is complex. I think you've already got that from Anna and from Martin. But just to emphasise, virtually every product and service is regulated. It's subject to taxes, duties, and not only national regulation, but there's international regulation, whether in the World Trade Organization, in trade agreements, there's international voluntary standards, and so on. That creates barriers between countries, and actually in many cases it creates barriers within countries where regulations can be made at state or provincial level, such, for example, that Canada has a free trade agreement with itself between the national government and the provinces. Barrier-free trade within a country is not actually the norm, even within the UK, as had been the case before 2016. It doesn't have to be a constitutional issue. It may be a constitutional issue. Barrier-free trade to multiple markets ought to be a very good position. My second point is that it's only within the EU that borders have been removed due to extensive regulatory harmonisation. And it's just as likely in the future that that will be reversed than that other countries will move towards having no checks at borders. The EU is particularly concerned about the purity of their single market, predominantly to keep their barriers down internally. So unless they can trust what comes in to the EU as a whole, they're worried that countries won't trust each other enough to keep their barriers down, and then the single market will disappear. The reality of a border as the place where the paperwork, the product, the driver all come together, and that's the one place everything comes together. Plus, the nature of ensuring safe food in particular leads to this conclusion. Technology can reduce burdens. It can make things easier, and for many vehicles, the most high-tech borders can feel relatively straightforward, but there is always the risk of delays. There is always the paperwork. My third point then is that the protocol is an attempt to manage the interaction of border and regulation in the context of Brexit. The implication of checks of products on entry to Northern Ireland was, I think, obvious immediately, and I think I saw Nigel Dodds say that earlier this week, that he and the Democratic Unionist Party warned the government of this within days or hours of hearing about the protocol. It isn't just probably from Great Britain to Northern Ireland either. The same is likely to apply in the future from Northern Ireland to Great Britain, unless the UK government voluntarily accepts that all EU products can be inevitably safe to enter, unless we don't wish to diverge or have higher standards. Because if we introduce new regulations which are more onerous than in the EU, how do we enforce them if there are no checks on products entering? I mean, I don't believe the UK government has addressed that point except in the vaguest terms. So there are likely to be checks under the protocol for the foreseeable future, potentially both ways. Does that international best practice or international norms would suggest that does not make Northern Ireland any less a part of the United Kingdom, but I accept that there are different views on that case. The fourth point for me, and this actually picks up quite similarly to points that Martin made, the heart of the protocol for me is in the 300 plus EU regulations that it requires Northern Ireland to follow, according to the annexes. Now, my own belief is that the UK government will have carried out a detailed assessment of these and their implications, which they have never shared publicly, or indeed, I just think privately. If they didn't do that more detailed investigation, I would be surprised, and that would be really quite irresponsible. There is a huge amount of detail that is required to be followed in Northern Ireland, as well as kept updated on a huge number of regulations. And I do agree with Martin that is an absolutely clear democratic deficit, that Northern Ireland has no say in the implementation, in effect, of these under the protocol. That was obvious at the time of signing. It was obvious at the time of ratification, and I still believe that issue needs to be addressed.
David, could I just interject there? Again, I should have made a declaration of interest that I used to be the Chief Executive of the British Irish Chamber of Commerce, and before Brexit, I was very much involved. There was an FCO-led, and then whatever we called Biz that day, scheme that looked at sort of the potential implications of Brexit and where it would lie, particularly in trade between Britain and Ireland. And there were something like a sort of 186 primary with 3 or 4 subsections to each, and it mapped it out. One of the key questions he asked was where we would be with the applicability of EU rules and regulations going forward, and the ability for any part of the the UK to absorb those if they're any separate. And I know you alluded to it, but I think you've said, and I just want to sort of hone into this bit, do you feel as if that the UK government has actually done the detailed research and analysis into those regulations, or was it a skim across? And I know it would be a slightly unfair question to ask anybody else, but I know you'll have looked at this.
It is my best judgment that the UK government has done at least some work on these regulations and what is contained within the regulations and what Northern Ireland will be required to sign up to. It is unlikely, I think, that they have done a very detailed assessment on all 300 or so and everything that is entailed within them. But I think that at the very least, I would expect them to have understood where, for example, within the 300 there are checks required, what kind of checks are required, and other things that have particular significance to Northern Ireland. And maybe that actually leads on naturally to the final point I was going to make, which is that both treaties and regulations are difficult to understand and interpret. They are typically frameworks for both sides to jointly implement in the case of treaties, or in the case of regulations for whoever has to implement them. they are very rarely so prescriptive that you understand immediately what you have to do in absolute detail. That is left to those doing the implementation. That, in my opinion, does not extend to the suggestion that any checks is the same as legal purism. It is fairly clear to me that the net effect of 300 regulations is that there have to be checks, but what those checks are, how often they are carried out, and details such as that, who does it, is, in my opinion, in many cases open to interpretation and to agreement. So that allows for the fact that the general basis of the protocol to me is clear that there will always be checks short of alignment. How they are implemented is not so clear, and what the overall implications are for Northern Ireland, I still believe, well, obviously we are having this discussion now, is clearly a very much a live issue. Thank you.
Yeah, thanks very much indeed, and thank you very much indeed, all of you, for your excellent sort of analysis and an excellent sort of talking to this committee. Look, I've just got a few questions before I open up to the rest of the group. And it's first one is quite a general issue, because I think news today is obviously the push about the new rules on state aid rules and how state aid is likely to be applied, and how the United Kingdom is looking at state aids. Does anybody have any indication how that is likely to work for Northern Ireland, and whether we're going to be in some way in a differential position when it comes to state aid? I think I already know the answer, but I would like to have your perspectives on it. The second question for everybody, I think, is the question about one of the questions about VAT and excise issues. And of course, one of the issues is that we're dealing with, on this island, we have differential VAT on areas from everything hospitality and other areas. The question is what sort of ability we would have within that context to be able to look to set VAT in a way that would be both seen to be competitive against our sort of friends down south, but also not to be in a position where we're going to get hauled in front of the ECJ every time we do it. And then the final one, I think, is probably more related to Katie, and thank you very much indeed for the Lucid Talk poll and what you were doing. But I think from what we've seen from the Lucid Talk poll and recent polling is that Northern Ireland has become very polarised. It's a very polarised place at the best of times, but we're now incredibly polarised over the sort of the protocol. And it seems to be, by looking at your figures from Lucid Talk and comparing them with some other things, is actually there's been a hardening of positions. So maybe, Katie, if you could come in at the end of it and just ask if you could answer that particular point. But over to you, panel, please. Thank you very much indeed.
Sorry, who would you like to start?
Oh, sorry. That's a classic position of sort of a Northern Ireland chair. He just shows it open to see who fights for it and comes up with the answer. No. Martin, if you could go first, and then we could, if we just have Katie come in last. Martin, David, and Anna, and then Katie, please.
I think rather than cover everything that you've asked, perhaps I can just focus on where I think I can contribute most. And the state aid question. There will undoubtedly be a differential in the state aid rules between Great Britain and Northern Ireland. At the moment, of course, the whole United Kingdom is still in effect carrying on with the EU system of state aid control, but the announcement has been, as expected, that the United Kingdom will create its own state aid control system. However, within Northern Ireland, the state aid rules are governed by the protocol, or rather the protocol imports the EU state aid rules with, for example, European Commission oversight. So the system will stay very much unchanged. A particular pinch point is the extent to which the state aid rules in the protocol actually also extend into and apply to businesses in Great Britain. The reason for this is that unlike, say, Article 5.2 that applies the EU regulations to, well, the words it uses are to the United Kingdom in respect of Northern Ireland, the state aid provision contains no such limitation. And instead, the limitation on the scope of the EU state aid rules is functional rather than by reference to geography. It's whether or not the aid will affect trade under the protocol, which is analogous to the current situation where the rules apply to subsidies which may affect trade between member states. And based on European Court jurisprudence, that is a very, very low threshold test. So that, for example, subsidising a car plant in England, which inter alia exports goods into Northern Ireland, would lead to an effect on trade in the protocol because that could impact on the sale of competing cars travelling from Germany into Northern Ireland. So that could well be caught within it. But I feel, as far as activities within Northern Ireland are concerned, it seems to me that it's under the protocol. It's just completely held within the EU state aid system, as I say, with oversight by the European Commission.
Okay, thanks. David, then Anna, please.
Only briefly to add to that. I'm sure that's absolutely right on state aid. I have the ongoing question as to whether the enforcement regime is actually quite the same as the enforcement regime as being an EU member, and I don't believe it can be. You've signed up in treaty to, in effect, the ECJ oversight, but I'm not actually sure that quite works. How we already know that the what has happened with regard to the UK's alleged breaches has gone to has gone to the ECJ, I believe, but you're not a member anymore. You're not. We're bound to it in treaty terms. It seems to be almost more of a discussion. So I think that the state aid, as in much of the regulatory interpretation, is still open to interpretation. Ultimately, I have to Martin shaking his head, but it's the way it's implemented. I'm just not sure that the ECJ are going to be able to work because the nature of the UK agreeing to it working in that way. I just don't see how that works. It's, the legality I'm sure is there. I'm not sure the implementation can quite be in that way. VAT, I would much sooner. I am absolutely not an expert, and I'm afraid you need a VAT expert. I would merely add that if Northern Ireland is polarised, I'm afraid that according to the opinion polling in Great Britain, we are also polarised. Not on the protocol so much as on Brexit as a whole. So I fear that we're all quite polarised.
Okay, Anna.
Thank you. I don't think these questions are necessarily for me. On the VAT, what I will add is that, yes, the dual kind of alignment, the dual VAT system is quite complex and comes with, VAT in general is complex like any other area of tax, but having a dual system doesn't help. And obviously, this needs to be viewed through the substantial changes to VAT accounting that will take place in the EU as of tomorrow. That will definitely impact SMEs, online sales, B2C sales, and so on. But in terms of whether it's possible and how to do it, I think that's more of a legal question, and I will defer to Martin really on that, because that's not really an implementation. That's how you do it from a legal perspective.
Okay, thanks, Anna. Kitty?
Yes, thank you. So just to answer these questions on polling, I don't want to confuse matters, but if I just refer to the Northern Ireland Life and Time survey, which is obviously quite a different type of survey, but we conducted that at the end of last year, and it's notable that half of our respondents pretty much were saying that the protocol is a mixed bag, with about 18-19% either side saying it's good or it's bad. So definitely what we've seen in the first few months of 2021 has been a polarisation that wasn't there before the protocol came into play, and perhaps before January the 29th and the implementation with the idea of triggering Article 16. I think we all know that was very significant. Another point is that when we had this, the first round of this poll in mid-March, those positions that we're seeing now were there already. So essentially what we've seen by June is that we've just seen a further entrenchment rather than an exacerbation of that polarization. And we see that polarization in terms of people who say the protocol is appropriate or not. So essentially 47% either side saying it's appropriate or it's not appropriate. And then when it comes to the question of how people want their MLAs to vote on Articles 5 to 10 at the end of 2024, again, it's pretty much even split as to whether they want them to vote for or against the continuation of Articles 5 to 10. But I think it's also important to recognise what people do agree on, or at least for a considerable part. So they do agree that specific arrangements are necessary for Northern Ireland to get out of Brexit. The majority agrees that there are economic opportunities for Northern Ireland from the protocol. The majority, as I mentioned, agree that scrutiny of decision-making around the protocol needs to be improved. They're very clear that they want more information and better information. There are concerns from the majority around the potential impact of Brexit and the protocol in economic terms, and the majority agree that the UK should align with the EU's rules to reduce trade frictions across the Irish Sea. So it's possible to focus on what divides people, and unsurprisingly, if you dig down into the data, you see strong differences between unionists and nationalists and neithers vis-a-vis the protocol. But perhaps it's also useful to concentrate on what people do agree on, because that potentially helps us see a way forward from this point.
Okay, thanks very much indeed, Katie. Jim?
Yeah, thank you very much, panel. And Martin Howe, I think you put your finger on a number of very important issues in identifying that really the protocol, the key lasting defining effect of it is the constitutional impact and import of it. And I wanted in that context to take you to Article 13.3 of the protocol, which seems to necessitate absolute alignment to the EU acquis on anything that touches upon the matters covered by the protocol. And the question to you was this: if those various identified regulations are subsequently amended by the EU or new regulations within that ambit are made, are they automatically applicable to Northern Ireland? Northern Ireland statute book in that sense has to be automatically updated, and they cannot be blocked by the United Kingdom. Is that correct?
Sorry, I turned my microphone off to avoid stray sounds coming in. It's different depending on the different aspects. Where an existing measure is amended by the European Union, then the amended measure as amended applies automatically to Northern Ireland. There's a slight distinction here between regulations and directives.
Yes.
A regulation, an EU regulation is, it's just like an Act of Parliament. It applies directly to citizens and businesses as part of the law. So if a regulation is amended, it will apply as amended within Northern Ireland without any intervening process. If a directive is amended, that creates an obligation on the United Kingdom to change internal law to comply with the directive, and there is machinery for carrying that out within Section 8C of the Withdrawal Act by statutory instrument. And of course, as you appreciate, the Assembly also has a role in statutory instruments in this field, but only limited discretions within what the directive allows.
So if the EU changes a directive, which is within Annex 2 of the protocol, then no matter what the United Kingdom Parliament thinks of it, no matter what the Northern Ireland Assembly thinks of it, it applies directly and unalterably to Northern Ireland.
Yes, the legal obligation it creates on the United Kingdom is there, and there is no choice but to implement it.
So,
the third area which you mentioned, is what if a new EU measure is adopted within the scope of the fields covered by Annex 2 to the protocol? And there it's slightly different. It doesn't apply directly. It has to be agreed jointly in the joint committee to apply it to Northern Ireland. However, the mechanism here is really very similar to, or identical to, the mechanism under the European Economic Area Agreement, under which Norway and the other EEA countries apply EU single market laws under the EEA agreement. And that technically gives them the right not to apply them. But if they do not apply them, the European Union is then able to take countervailing or retaliatory measures to suspend the EEA agreement or aspects of it. And in practice, I think there has been no occasion when Norway or the other EEA states have held out against implementing new European Union directives. The Norway tried to hold out for a couple of years, I think, on the Postal Services Directive, but were induced to give way in the end. So although it doesn't apply automatically, there are mechanisms for applying pressure to, in effect, push Northern Ireland into accepting it.
So de facto, it's EU rule through that. But on the point that let's stay for a moment with a regulation which is varied by the EU. Parliament can't change it in the United Kingdom. Assembly can't change it. So it effectively is regulation without representation. It's hard to think of that as anything other than putting Northern Ireland in a state of vassalage, is it?
Well, that's your word, but I'm not sure I don't disagree with it, because it is the application of laws in which, citizens in Northern Ireland cannot vote on them by any route. You can't vote in the Assembly elections to get rid of it because the Assembly has no power to do it. You can't vote in Westminster elections to get rid of it because the Westminster Parliament has no power to do it.
And does anyone on the panel think that by the standards of democracy that we expect in 2021, that is acceptable? Does any panel member think that's an acceptable imposition in respect of Northern Ireland?
Can maybe join this conversation. I had already mentioned that there is a democratic deficit, but I do not believe that it is as stark as that, because when we are talking in the reality about regulations being made, they are being made on specific subjects. So what are the options that are available to the UK government in this? Well, depends on exactly what the regulation states. But there may be the opportunity to pass alternate regulations. There may be the opportunity, as we have already seen, to say to the EU that is unacceptable. We cannot go with that. This is not it is not. You're putting it as a one-way street in which the EU rules. If the EU rules tomorrow, that's it. Everything falls into play. That, in reality, the way that laws are made, that is not quite the case. And I say that having already accepted fully an agreement that there is a democratic deficit, but it is not quite as I think as you can make it more blunt than it really is.
Are you disagreeing with Martin Howe when he says that a regulation currently applicable under the protocol, if it is changed solely by Brussels, as it would be, that the United Kingdom can do anything about it? And if so, where within the protocol does that provision exist? With respect, you are wrong.
It is in the implementation of individual regulations, number one. Number two, there is clearly always the opportunity, as we have already seen, for discussion between the UK and the EU. I am not arguing that there is that actually we have much of a choice, but I am saying that to bluntly say the EU rules on this today and tomorrow we implement does not have to be the case.
Well, with respect,
there is more greater complexity to the implementation of regulation than simply they rule, we follow.
Well, you're doing your best, but with respect,
Jim,
it's quite clear under the protocol. It's the EU writ that runs with respect to these matters.
Jim, it's hard enough doing this through Zim. Please, through the chair. Thanks.
Yes, Chair. I'm suggesting that no matter how you dress this up, the plain fact is that on the issues that have been identified in respect of these regulations, which the EU alone can change, it is the EU's writ exclusively that runs in Northern Ireland.
I will disagree with you on that. That's not how I would interpret the way in which regulations are made. Yes, the EU has a very strong power. No, you do not have democratic influence over what the EU does, but there is still room for the UK government and for the Northern Ireland Assembly to be making decisions on exactly what they are. We have to look at specifics of the individual regulation. It's not possible to make a generic statement of this that all regulations are immediately implemented in this way.
Sorry, could I ask Martin Howe then, do you wish to vary or change what you've said if your colleague disagrees with you? Or do you stand by what you said?
No. I mean, I think if we specifically take the case of European Union regulations, not directives, but regulations, they are directly applicable inside member states, and under the protocol are directly applicable inside Northern Ireland. That means that you can go to court and enforce them without the legislature or the government doing anything to bring them into force. And if we take the example of the European Union on medicines, centrally authorised medicines by the European Medicines Agency, that is a regulation which is directly applicable. And if that is amended by the EU legislature, then it will apply as amended in Northern Ireland with no intervening process of negotiation or otherwise. I mean, of course, the British government, the British government could go to the EU and say, please amend it in its application to Northern Ireland and plead for it. But there would be no precursor negotiating step before it came into force and was directly effective in the courts.
Thank you.
Okay, thanks very much, Steve. Phil?
Okay, thank you, panel, for your points so far. Just a couple of points following on from Jim. And it's to you, Martin. You referred, and it's the same points that Jim made, that Northern Ireland is to accept laws not relevant to other parts of the United Kingdom due to the protocol. And then you went on to say it's democratically and constitutionally affecting Northern Ireland, and something more radical needs done. In your learned opinion, Martin, what do you mean by something more radical needs done?
Well, I mean, my own view is rather than trying to implement, I think the protocol is basically flawed because, I mean, Anna has talked about the customs side, where at least there's a system which says that if goods are not at risk of going across the border, then you don't have to pay tariffs on their importation into Northern Ireland from Great Britain, or at least you can get them back if they have been paid. That there is no such let out as regards regulations on goods. The EU single market laws on goods apply completely and entirely to goods which are made in Northern Ireland, consumed in Northern Ireland, or made in Great Britain, imported to Northern Ireland and consumed in Northern Ireland, even if there is no risk at all of them crossing the border. This is a fundamental flaw in the construction of the protocol. It goes back to the way Theresa May negotiated it, with, I think, motives of trying to, in her vision, get the whole United Kingdom stuck permanently in the European Union regulatory sphere rather than negotiating it from the point of view of an independent country, it's still there, and I think it will have to go. The way I'd like to do it would be for Parliament to pass an act that said that the UK Internal Markets Act prevails over the protocol, so that goods lawfully on the market in other parts of the United Kingdom can then be freely imported into Northern Ireland.
Thank you for that. And just one final question, if I may, Chair. And this is to all the panel. I would like every individual to answer this in some regard. On three aspects. Are you all aware that Northern Ireland is part of the United Kingdom? Are you also aware that whenever we voted to leave the European Union, we being members of the United Kingdom? And what do I tell one of my constituents, or thousands of my constituents who voted to leave? What do I tell them now?
Sorry, if we'd, Katie, do you want to kick off on that one, because it's a sort of political nuance from Northern Ireland, so you can handle that one?
I don't know if there's too much nuance there. I mean, yes, Northern Ireland is part of the United Kingdom. Yes, the UK as a whole voted to leave, but Northern Ireland voted to remain with a majority of 56%.
Yeah, but just
to your questions, Northern Ireland is outside of the European Union.
Yeah, but just if I may come back, Chair.
Just one moment, yeah.
We are part of the United Kingdom, irrespective of many people voted to leave or voted to stay. We're part of the United Kingdom, so if the United Kingdom voted to leave, we leave. It didn't say anything different in my ballot paper. I'm sure the rest of the people in this room had said the same thing, unless mine was different. So we voted to leave. The United Kingdom voted to leave.
Northern Ireland is outside of the European Union.
Okay, thank you. David?
Apologies, I thought I might have been on mute. I don't think in all the discussions I have had about Northern Ireland that it has ever been a question to myself or those I've been engaging with as to whether which way the vote went in different places, or what the status of Northern Ireland is within the UK. The points I have been making are about the fact that you can be within a country and there be trade barriers, that is actually common within countries to do that. It is actually fairly common that you can end up following regulations of another country. These are political issues and political choices that have to be made. I've made my points, my position clear that a Conservative government, oddly enough not one led by Theresa May, signed a deal which I do regard as flawed. I regarded it as flawed at the time, but that was what the government signed up to. But I think that it requires a serious political discussion, because it is not that there is any simple answer to how to reconcile the question of regulations and borders. There has never been since 2016, and there still isn't a simple answer to that. But I do think we need a proper political discussion, and that the treaty was passed through with, 7 hours of discussion I saw today in Parliament, and that was clearly not sufficient.
Okay, thanks. Martin?
Yes, I think the way I put it, probably, I hope accurately, is that Northern Ireland is only partly out of the European Union, and it remains partly inside it. And in one sense, it's completely out, in the sense that no longer do voters in Northern Ireland have the right to influence policies and laws of the European Union by participating, nor can its government representatives participate in the making and shaping of those laws. It's partly out in another sense, in that large areas of EU law no longer apply. For example, single market rules on services don't apply. However, in the area of single market rules and laws on goods and the associated treaty provisions, for example, on the free movement of goods, those continue to apply to and within Northern Ireland. They apply as if Northern Ireland was still a member state. The legal mechanisms are identical, in that the courts of Northern Ireland, when interpreting these laws, would make preliminary references to the Luxembourg Court on points of difficulty or doubt, and their rulings are, the ruling of the Luxembourg Court is binding, in the same way as if we were still a member state. So I would say, whatever the reasons why we've got here, Northern Ireland has not yet completed the process of leaving the European Union. It is still in partially and in important respects.
Okay, thanks very much.
Thank you, Chair.
Thanks very much. Anna?
Yes, while I will not address the political kind of side of this question, I will say this. The protocol does state very clearly that Northern Ireland is an integral part of UK's customs territory, although, as we very well know, other provisions of the protocol give it a dual status. Since 2016, it was clear that there are only 3 places that if you have divergence, which is something that we wanted from the beginning, to be free to strike our own trade deals and so on, that the border in a way needs to be somewhere, and there were only 3 places, or the variation of these 3 places where the border could have been placed. I think I will very much stress what David said. There were no easy, clear, simple solutions here. It was always going to be an imperfect solution, because nothing like this, there are no off-the-shelf models, there are no simple solutions here. So we ended up with a protocol, and now trying to see how we can work and make the provisions and the implementation of the protocol more flexible. But this was never going to be in any way easy or a solution that satisfies everyone. That was just not possible.
Okay, thanks, Anna. Gemma? Gemma?
Thanks, Chair. Can you hear me okay?
Yeah, we can, Gemma.
Thanks, and thanks to the panel. And I know that Keith is concerned about what to tell his constituents. I'm also concerned about what to tell mine, because the majority of them voted to remain. But I just have one question for Katie. And Katie, it's notable today in your survey that most thought that there were economic opportunities for the North in the protocol. How do you think we can start to build on that majority?
So this is the question of whether Northern Ireland can potentially have the best of both worlds. I mean, it's worth bearing in mind that I don't think it's too controversial to say that if the majority of businesses in the UK as a whole could have no trade frictions on movement of goods with the EU, that they would be very glad of that. And that is, of course, what Northern Ireland has with respect to goods as a result of the protocol. But of course, it's more complicated than that. And there's the fundamental necessity before I think the full economic opportunities of the protocol can be seized upon, such as they exist, is the question of stability and certainty. And you yourselves have heard how often that request is made by businesses. It's been made for a long time, and it's having to be repeated. And the degree to which the UK-EU relationship is one of current levels of distrust and still quite a lot of bargaining and politicking going on in that relationship, that really is not conducive to creating the kind of environment for business and indeed for politics in which then those economic opportunities can be seized.
Thank you, Katie. Thanks, Chair.
Okay, thanks very much indeed. Philip?
Yeah, thank you, Chair. I mean, and just in terms of coming in at the beginning, I just want to kind of elaborate on Anna's closing remarks about, this is not easy and has never been done before. And I think it's important, even though it may be very repetitive, to just put that on record that, this discussion about the protocol is because of Brexit, and in particular it's because of the hard Brexit forced upon us by the Tories and the DUP. And all the discussion about the democratic deficit, I think it's important to remember that the majority of people in the north didn't vote or support Brexit. And just because you make your argument forcefully or loudly or arrogantly, as perhaps some of the committee members have done to this point, doesn't mean, as was proven in a court case earlier on today, that your argument actually is right or stacks up. So I think that those points are important. Just in terms of following on from Gemma, in terms of the survey, I mean, I haven't obviously looked through all of it, but the headline points, so if I could maybe ask Katie, in terms of more input from stakeholders into the operation of the protocol, how do you think that would perhaps change people's opinions on it? And then, if most people, I suppose, support businesses when they're talking in relation to the protocol, maybe more over other groups. So, I mean, do you think that the vast majority of business representatives want to make the protocol work? And then separately, maybe to David and or Anna, in terms of the Swiss-style SPS equivalence deal, how would that help with the problems we're experiencing, and why, in your opinion, do you think that the British government are actively blocking it? And then, I sit obviously also on the Agriculture, Environment and Rural Affairs Committee, and we're particularly worried about the impact of the Australian free trade agreement with farmers. So, in your opinion, what kind of damage could that deal do to local farmers here, pushing them out of, potentially pushing them out of the British market, and also any future free trade agreements that are also likely to cause more damage to local exports?
I'm happy to come in first. So I don't want to say things that I don't have evidence to say. So with respect to the poll, of course, we didn't ask people what type of input they want to see. But I can refer to a report that I published with my colleague David Fenimore and others last year around meeting the challenges for governance for Northern Ireland post-Brexit, post-protocol. And just one element that is relevant there and could still be exploited is, of course, the Joint Consultative Working Group as a new institution, UK-EU institution for operating the protocol. And the way that it has been developed is a sort of a minimalist model, if you like, at the moment. So it's basically involving UK-EU officials, although there is an invitation to NI officials. But there's plenty more scope in that for being more imaginative around how Northern Ireland officials, but also Northern Ireland business, Northern Ireland elected representatives, and Northern Ireland civic leaders, how they may feed in JCWG. Because it's important that that advice that goes from that group, which meets weekly, into the specialised committee, will be the type of thing that informs the decisions, the recommendations made by the specialised committee. And this comes back to the point that Mr. Alistair was talking about earlier, i.e. the degree to which they are even aware of the possible implications of these amended regulations and directives on Northern Ireland. So there is plenty of scope, and in that large report I make 80 recommendations as to what else might be done, but that's just one little thing to note. And your question around the majority of businesses, again, I don't have evidence to say the majority of businesses, but what are supportive of the protocol, but it is very clear. I mean, overwhelmingly, as I mentioned before, they are looking for stability and certainty, for agreements, for clarity, for information, and Anna will attest to this as well. And it's possibly a good point at which to mention, of course, Article 6 of the protocol, charging the Joint Committee with responsibility for both UK and EU using best endeavours to respect Northern Ireland's integral place in the internal market of the UK, and of course in the UK Internal Market Act, which has also been mentioned here, Section 46, for the UK government itself to act with special regard to Northern Ireland's place in the internal market. If they did that, then we could have a situation which we know from polling evidence over the past few years that the majority of people in Northern Ireland want, and that is minimal friction on either the Irish land border or the Irish sea border. And it's only through working to that end, avoiding the hard Irish land border, minimising the impact of the protocol and movement of goods across the Irish Sea, and then we get the best position for Northern Ireland's business. Okay.
Anna, do you want to come in there?
Yes, of course. In terms of a Swiss-style SPS agreement, yes, that would eliminate a number of checks. According to EU estimates, it's about 80% of checks required. It would simplify things. You would not necessarily need to provide, well, you would not have border checks for a lot of the products. You would not necessarily need to provide the certificate. Some of these products that we're talking about that are banned or could potentially be banned would not be banned. But there is also the second side, or the other side of this Swiss-style agreement, meaning that Switzerland follows EU rules with, as far as I understand, only a very limited impact on these rules in terms of what it can do once the EU has passed its rules. So the Swiss are aligned with EU rules on that, and that obviously, one of the difficulties that we keep having, not only with the protocol but with Brexit in general, is these hard choices, these trade-offs. Yes, you have a solution here, but this is the consequence, and I think this is why we keep kind of struggling with these issues, is that it would solve some problems, but it would potentially create another level of problems. One of the kind of solutions that are maybe not on the table, but let's say table adjacent, is this Swiss-style agreement with an opt-out clause, meaning that at the point where the UK wants to diverge in terms of rules and regulations because it's signing an agreement with someone else or for some other reason, it could potentially then opt out from this Swiss-style veteran agreement, but it still means accepting EU rules for the duration of this agreement being in place, which is which is a trade-off in that respect. So I think it's not. Unfortunately, it's not a discussion about technical solutions and what's possible from a technical perspective. It's a discussion about where we want to be politically, and this makes it incredibly difficult and incredibly challenging. On the Australia one, I would just say, and I think I'm sure David will add to this, so I would just very briefly say that we're still waiting to fully understand how imports from countries where the UK signed a trade agreement will enter Northern Ireland if they're not going through GB. We have some guidance. That guidance is not entirely clear. There's a typo in that guidance, which makes me feel that this is potentially not the final version of that guidance. And we're still trying to understand how it's going to work if, for example, the UK has an agreement with Australia, but the EU doesn't yet. If there's the gap, how will these imports be treated in Northern Ireland? So I think this is a very important question, and we don't fully have an answer yet.
Okay, thank you. Okay. Alicia?
Chair, okay. You able to hear me, Chair?
Yeah, got you.
I'm Forfeiture overlake. I feel very welcome here this afternoon. Very, very interesting listening to your comments now as well too. It always intrigues me, when I hear people commenting on democracy or the lack of democracy. Probably it's something we're well used to here in the island of Ireland, whether we go back to the Act of Union of 1801 or the division of Ireland in the first place. Democracy was always ignored. They never had the permission of the Irish people at any time, no more than leaving the EU has at the present time. Not only for the majority of us who live in the north of Ireland, but without doubt, by far the majority of people that live on the island of Ireland wish to remain within the EU. And that's quite clear. But notwithstanding that, given the rules as they are currently, the UK voted to leave the EU. The UK also elected its government, which is the British government at the present time, who, on behalf of those same people, negotiated an agreement with the EU. So that in itself, the British government were given that permission and negotiating that agreement, we are in a situation now where we have to deal with a protocol where that same government, having negotiated it, in my opinion, they have totally dragged their feet in the implementation of the protocol. So to ask all of the panel members just in relation to that, to what extent do you think is there reluctance in the implementation of the protocol creating many problems for people, and even right down to this whole issue of identity politics and the likes of it as well too. By far, I think the greater part of businesses, from what I see and understand anyway, that they are the very people who are probably coping with the problem and dealing with it very, very successfully. And here on the island of Ireland itself, there's a lot of evidence at the present time that because people now are identifying suppliers here on the island, and only yesterday, again, a flour production company here in the north of Ireland that is supplying its flour to bakeries and that within the 26 counties. So it has its positives for us ourselves. So to what extent, as I say, do you think is it that reluctance on the part of the British government and implementing an agreement that they made on behalf of all of the people of the UK that has given rise to many of the problems that we're faced with at the present time?
Okay, thank you. Can I start with David on that one, please? Then David, Martin, Anna, and then Katie, if you've got some comments on that.
Thank you, Chair. Like I have said fairly frequently, that I think there's a major problem with the UK government having signed a treaty that implies checks and then kind of not actually being honest about what it was that they have signed up to, and have been quite obstructive in the implementation. I'd like to, I pay tribute to Northern Ireland businesses, Northern Ireland Business Association, so I think I've had to bear the brunt of this and have done a fantastic job and have worked ceaselessly in doing so. And I don't think they've really received very much help from the UK government, which I think is trying to have it all different ways. It's trying to on the one hand, it says it doesn't really want the protocol, but on the other hand, when push comes to shove, because of the relationship it wants, particularly with the United States, it does want the protocol. And I think that is actually quite dangerous behaviour to suggest on the one hand you might walk away from it, and on the other hand, in your actions, that you won't walk away from it. So I think that is very difficult to work with. I think we'll struggle to make progress unless the UK government can be more open about how it intends to take forward the protocol, to work really with all concerned, because there are numerous issues, and yes, many of them do apply to east-west ties, but there are issues as well relating to north-south business ties. There are issues with services. We very rarely talk about services. And even in areas like free trade agreements, because I think that was a little bit of a holdover from last time. If Australia sends a lot more beef and lamb to Great Britain, there is a strong chance that that Northern Ireland businesses will be some of those, more Northern Ireland farmers will be some of those who lose out. And I know there was a letter sent recently by the Agriculture Minister from Northern Ireland on that subject. So I think there is a lot that the UK government needs to do to help put right, is being open and about honesty about what it's signed and what the implications are. And I think without that, it will be very difficult to resolve that. I hope that we can resolve it for the sake, as I say, of the businesses and the communities who have worked so hard to make the arrangements work.
Thank you, David. But in your answer, just could I also ask you, just as a follow-up to that, do you think it's any alternative to a protocol?
I think that, as Anna has already said, this is a very difficult, we're on uncharted territory in terms of that there need to be either we have to align in some ways, and we could do that in food and drink, or we are going to have checks somewhere. We can, over time, perhaps build up more trust, but ultimately there has to be something. There is going to have to be an agreement for how trade between Northern Ireland and the rest of the EU, and also movement of goods between Great Britain and Northern Ireland operates under Brexit. So there has to be something that looks a little bit like the protocol. It could be varied in different ways, but there is going to have to be some form of, almost certainly some form of treaty and some form of supporting political agreement. And personally, I think one of the issues is that there was no form of political agreement really running alongside the protocol to explain really to everybody what the protocol meant and what the implications are, and to make sure that more people were comfortable with it.
Good, David. Thank you.
Thanks very much. Matthew, can you come in? And can we, I don't want to foreshorten you, but we've got some more people to listen to after this as well.
Okay, well, Mr. Allister had a very long time to expound on his very particular views, so I will ask
my indulgence. Is that what you're going to say, Matthew? Yes.
As pithily as I can, Chair. Thank you for your indulgence.
Mind you, Mr. Allister was here in the beginning of the session.
I see he's left now. Can I just ask Martin, first of all, Martin Howe, QC. Martin, you wrote, I think, a number of pieces in late 2019 when the withdrawal agreement was updated by Boris Johnson saying that this deal was tolerable. What changed?
The words I used were very carefully chosen. I thought it was tolerable, really, when you looked at the alternatives in the political situation. I can say personally, I've never liked this deal, and indeed the Northern Ireland Protocol is the worst aspect of it, in my view.
Okay.
The reason I wrote those articles was that perhaps the alternative would be a complete collapse of the entire Brexit. The government chose to go down the route of doing this deal with the Northern Ireland Protocol, and that in effect became the only route, however imperfect, out of the European Union.
Okay.
So that's my personal answer to that question.
Fair enough. Having said that it was imperfect but better than the alternatives, could you please elaborate on your alternative as of now to the provisions in the Northern Ireland Protocol?
I think the fundamental problem with the Northern Ireland Protocol, as I've explained, is the application of European Union law inside Northern Ireland. And that, it seems to me, is the feature that should be removed. Now, you then come on to the question of how do you control the flow of goods across the border, the land border, which, of course, is the root of the whole problem. But, there are other ways of doing it. For example, if you take medicines, now medicines are entirely controlled in their distribution channels. They can only be stocked by authorised pharmaceutical wholesalers and retail pharmacists and so forth. So you're not going to get people with, barrow loads of prescription medicines carrying them across the border and infecting the European single market with drugs they don't want. So you can have other systems of control on businesses that can result in preventing the flow of non-conforming goods going across the border, and without the need, I think, for physical infrastructure on the border. I mean, this sort of idea that if you put a man with a pole, with a peak cap and puts a pole across the road, that's some sort of effective control on the movement of goods is rather fantastical in current conditions and the way that customs and regulatory controls are in fact implemented.
So is what you're saying that there shouldn't be, Northern Ireland should not be, for the purposes of regulating the movement of goods or indeed for customs control, Northern Ireland should be in precisely the same position as the rest of the United Kingdom? Is that what you're saying?
Indeed, I would like to see that, but what I think you could say is that one could assist, if you like, the European Union in its desire to prevent the importation of either goods which have not paid proper tariffs or goods that don't comply with its laws, by having obligations on businesses in Northern Ireland not to export south of the border unless the goods are compliant with EU law and Irish Republic law.
Okay, so what you've just said is that there should be an obligation on a legal obligation on economic actors in Northern Ireland, which would seem to contradict the first part of your answer, which is that Northern Ireland has to be in precisely the same position as the rest of the UK. If you think there should be a legal obligation on economic operators in Northern Ireland around how they export goods on the island of Ireland, doesn't that mean that they are going to be treated differently?
Well, only if they choose to export goods across the border. I mean, you could have the same obligation on. If businesses in Great Britain send goods across and across the land border into the Irish Republic, you could have the same obligation on them. It's the question of you only become subject to the obligation if you choose to become involved in exporting goods. That's the important point. So internal manufacture, internal production, marketing and consumption of goods is outside the ambit of EU law.
Okay, I'm not sure that makes sense, to be honest, but to me at least. But if we go back to your statement earlier on that Northern Ireland remains in part in the European Union, would you accept that Northern Ireland's constitutional position, as actually confirmed today in the High Court here, is that Northern Ireland remains in the United Kingdom unless and until the majority votes for it to leave the United Kingdom?
Can I say I've seen news reports of today's judgment, but I'm not sure there's, certainly if the transcript of the full reasoning is available, I haven't seen it. So I can only make limited comments on it. And I mean, in one sense, it confirmed what I thought to be the position, which was that the Articles of Union of 1800 are indeed overridden by the 2020 Withdrawal Agreement Act and the Northern Ireland Protocol. On the question of does it, yes, Northern Ireland is part of the United Kingdom and it remains part of the United Kingdom. Yeah. However, it does seem to me that its constitutional status in the United Kingdom is altered by the protocol, because its previous constitutional status under the Articles of Union involved the free movement of goods, indeed, and without customs controls and without regulatory barriers, to and from other parts of the United Kingdom. I believe that is a constitutional matter because it actually is an important aspect of both the Articles of Union between England and Scotland and with Great Britain and Ireland to achieve an internal market and having a single external customs system without internal barriers.
Okay.
So that aspect of the Constitution has been altered in relation.
You just said regulatory barriers between Great Britain and Northern Ireland. Is it therefore your view that the checks for sanitary and phytosanitary products between Great Britain and Northern Ireland that have existed for the entire history, since as long as those checks have been mandated, that they were also a constitutional violation of Northern Ireland's place in the UK?
No, I don't think so. I've written on this subject to some depth. Checks on, for example, infected cattle passing from the island of Great Britain to the island of Ireland are a rational means of preventing the flow of infections. I mean, if such checks are imposed, and sometimes they are, if there's sort of foot and mouth outbreak between England and the Isle of Wight, that doesn't affect the constitutional position of the Isle of Wight as being part of England.
You just said that
I
checks to prevent animal and for animal health purposes are rational and do not affect the constitutional status. Isn't that literally what the protocol is?
No. I think that this is a sleight of hand. What the protocol is talking about on things like SPS checks and things on sausages is nothing like those sort of live infection control. I mean, in fact, the powers of the original Stormont Parliament included, they were restricted from imposing generally prohibitions on importations from Great Britain, but it specifically included health powers. They were allowed to do that. So this has been constitutionally accepted for a very long time. But what we're talking about here are not, controls on chilled meat. Have got nothing to do with preventing diseases, cattle diseases, flowing from one island to another. They're there for economic purposes, in order to provide a restriction, largely which allows EU producers who don't face such barriers an economic advantage. So I don't regard those as legitimately in the protocol, and I do think that introducing them does affect the constitutional place of Northern Ireland within the United Kingdom.
Since the checks already existed, I'm not sure I agree, but on the Act of Union, if I could, Article 3 of the Act of Union, you have talked a little bit, and I know in the past, and you've been party to applications to the court on various issues of some, I believe most of which have been rejected. But Article 3 of the Act of Union specifies very briefly that the said United Kingdom be represented in one and the same Parliament, to be styled the United Parliament to the United Kingdom of Great Britain and Northern Ireland. If Article 3 of the Act of Union provides for one Parliament alone, wasn't the creation of the Northern Ireland Parliament in 1921, indeed the Scottish Parliament in 1999, and other devolved assemblies, didn't that violate the Act of Union too? Doesn't it imply that the Act of Union is one of a number of constitutional statutes which evolves over time?
Perhaps we're talking slightly different purposes. I don't think the establishment of devolved, whether the Parliament of Northern Ireland or the Scottish Parliament or the Welsh Assembly violates the Acts of Union. My comment is related to the issue of whether or not the Northern Ireland Protocol effects a constitutional change on the position of Northern Ireland. It definitely overrides the Act of Union.
My point,
and in my view, it does result in a constitutional change.
My point to you was not that was not about Article 3 in and of itself. It was about the idea that the Act of Union is totally unamendable, and that amending it changes the substantial constitutional position of the United Kingdom. And given that that has happened multiple times, as was said in court today, surely that is something of a straw man.
I think with respect, there are different points there. The Act of Union is amendable, and that is clearly the case. And if it is amended, and depending on how it is amended, that may result in a constitutional change, because it is a constitutional document.
Thank you, Chair.
Okay, thanks very much. Pat?
Chair, you'll be pleased to know mine will be small, and I want to thank everyone there for their information that they give to me. I suppose we have to look at the problems or the good points of the protocol. I don't think there's anyone in Northern Ireland that wanted any sort of protocol, but as already been stated, the majority of people here did vote for Brexit. We have what we have here, and we have to look at it. Can the panel tell me, can you comment on how you believe the UK government could or should apply the financial assistance powers provided, which you've already alluded to at the start? But I want to bring it in with the comments on whether Section 46 of the UK Internal Market Act contradicts the provision of the Northern Ireland Protocol. And last but not least, the protocol is here. We fool people if we're telling people that we're going to be able to change that. It's here. It's an international agreement. And I want to know, can the panel tell me how we can make that work to the benefits of everyone here in Northern Ireland? Because let's speak about the benefits and not the negativities of it. Please.
Okay. Sir, can I ask anybody to put forward some of the benefits that they see from the Northern Ireland Protocol that they can evidence? Thanks very much indeed. Anybody, please?
What's your answer, Paul? There's no.
I'm happy to go first, Chair.
Yes, please, David.
Well, I have contacted by businesses to discuss issues around Brexit, and the question, several of them, it has come up. So if I move to Northern Ireland, will many of my problems be resolved? And I've been able to say yes. You can. Those companies who, for example, were using a warehouse within Great Britain for supplying the EU, if they were to move said warehouse into Northern Ireland, then as things stand, they are going to be able to supply both the EU and Great Britain. The problem, as I think somebody has already mentioned, is if they're not sure that might all change next week, then that's not a great basis for an investment decision. But that opportunity is there, and I can assure you that businesses are interested in that opportunity if they believe there is stability. And I think that comes back to the first part of the question: can you make the Northern Ireland Protocol better? I think it requires new dialogue within Northern Ireland and with the UK government to basically look at some of these problems, not to come up with fantasy solutions where the EU is suddenly going to trust us not to have any borders. That's not going to happen. But that there are things that can be done if there's an open and honest discussion. Maybe it's not so much of a problem to align in some areas with the EU, in some food and drink areas, which would remove a lot of the checks. The medicines, I think, is close to being resolved anyway. I think a lot can be resolved, but it needs that kind of proper political discussion, and then I think you can potentially see a business benefit as well. And for those who might want to see it, and I was thinking about this earlier, you may actually find that if businesses from Manchester or London started to set up in Belfast, it would actually strengthen their support for the Union of Great Britain and Northern Ireland. But at the moment, things are too unstable for that. But in terms of the way the UK government is approaching this, but I think there are opportunities, but undoubtedly there are huge challenges as well.
Okay, Katie or Anna?
I can just add one point. I agree 100% on stability and certainty. Investment decisions are made well in advance, and not knowing what's going to happen in Northern Ireland next year is not helpful. If there's one thing apart from stability and certainty that the government can do to maximize opportunities, I'll say that, although I'm not sure if this is the right term, is provide more and clearer guidance on how things operate at the moment under the protocol. It's still, the devil is very much in the details. It's still so much more difficult to find information about how things work in practice in Northern Ireland than it is in GP. Clearer guidance, more availability. I mean, you have a second parent or TSS, but the fact that you can't get answers about what's happening in Northern Ireland on customs from HMRC, because HMRC refers you to TSS and doesn't want to take questions necessarily on Northern Ireland, that's not helpful. So more guidance, more information, that would help.
Okay, thanks very much indeed. Katie?
Yeah, I would underscore what Anna has said there. That's very much a pressing concern from business. I mean, in terms of the benefits of the protocol, it's a difficult one, because you're thinking, well, what's the counterfactual? You know, is it that there was no Brexit at all, in which case we would continue to have free movement of goods, services, people and capital across all our borders? Obviously, that's the protocol, as with Brexit, brings frictions Or is the counterfactual the possibility of an Irish land border? And if we recognise now, at the very least, what a customs and regulatory border means, surely this does underscore the difficulties that we would have faced if we were to try to be managing this across the land border, recognising the seriousness with which the EU enforces its laws and wants to see it those rules applied. One small question is, of those 300 legislative instruments, which of those does Northern Ireland not want to follow, or does it want to diverge from? If we're in a different situation outside of the protocol, but I would stress, and you'd expect me to do this as a political sociologist, I mean, those questions around democratic deficit, scrutiny, and governance, those are questions that are going to become increasingly significant if and when those practical concerns around the operation of the protocol are addressed.
Okay, thanks, Katie. Martin, just to finish up.
Well, yes, you've invited me to say what are the good things about a protocol where I can't frankly see much that's good in it. Obviously, what is touted as its principal benefit is the ability of businesses in Northern Ireland to export into the EU single market without barriers. And indeed, that is an aspect of the protocol. But even that is inhibited. And the example, coming back to the example of medicines regulation, which I gave, although the protocol applies the European Union's medicines regulation and medicines directive to Northern Ireland, the Annex 2 contains a couple of very specific exclusions which do not permit businesses in Northern Ireland to act as the they're not. In other words, you set up a pharmaceutical company in Northern Ireland. It is not. It's excluded from being treated as if it were in the European Union for the purposes of those regulations. So you can't apply for a European Union central authorisation from an address in Northern Ireland. You can't be a qualified person for the purposes of these regulations if you're resident in Northern Ireland. So even in that respect, it is flawed. And of course, I agree with the point David made that in order for businesses to take advantage of this system, they would have to have confidence in the stability of this scenario. And my own feeling is that it is very much very long way from being a stable situation.
Okay, thanks very much indeed. Tim, that's quite a long evidence session, and I thank you all very much indeed for your forbearance, and thank you very much indeed for sort of giving the full answers that you have indeed as well. But just finally, on behalf of the committee, may I thank Katie, Anna, David and Martin, and no doubt we've still got a long way to go on this. And sorry for if you saw me looking down at my screen, but I've just seen David Frost's comment that it's coming out about sort of the chilled meats piece, but I haven't yet seen Maria Sefcovic's piece as well. So we're continuing as we go on with the great sausage war. But thank you very much indeed, and thank you very much indeed for your evidence. Thank you, everybody. Cheers. Team, if we're moving on to the next item, it's again some more evidence on the Northern Ireland Protocol. It's focusing on Article 5, the customs and movements of goods. We've got Christian, Shanker and Robert coming on. Could I ask them to come into Starleaf, please? Who have I got? Yep, all there. Sorry, Christian, Shanker, Robert, Steve Aiken here. Sorry, look, apologies for being slightly delayed, or sort of quite a lot delayed in bringing you on for the evidence session. We've had quite a long session. We've already discussed quite a few of the issues with our previous expert witnesses on the protocol, and for that I apologise, but welcome, and you're very welcome indeed. Christian and Shanker, it's good to see you again, and we look forward to what you're going to say. Team, I just want to say the session has been recorded by Hansard. Peter's briefing notes at page 130. a briefing paper from Mr Lowe is at page 132, and a background note for the Trader Support Service at pages 135. Hopefully you will have all had a chance to listen to the earlier session. You're welcome to add any opinion or any issues you've picked up on today. But to begin with, can I ask each witness to make an opening statement of about 5 minutes, and then I would ask Mr Benson and Mr Singham to begin with first. So Christian, over to you, please.
Thank you, Mr Chairman. A pleasure to be here, and thanks to you and the committee for inviting me to say a few words to provide members with an overview of the Trader Support Service. As the committee considers the Northern Ireland Protocol and Article 5 on customs and the movement of goods, TSS provides practical insight into the movement of those goods from GB to NI throughout the period that the protocol has been in operation. And it's from this practical perspective that we provide our inputs today. So with 6 months of live operation, we're able to draw on data on the movement of goods, and through interactions with thousands of traders during this period, we can provide insight into how businesses are interacting with both our system and the new requirements arising from the protocol. We're incredibly proud of the progress we've made to date. TSS has been rolled out and delivered at pace from a contract award in September to live operation at the start of this year. All of that under COVID-19 restrictions, with most of the team actually never having met. TSS is working. The role of TSS is to make sure that trade between GB and NI is as free-flowing as possible, consistent with the legal requirements of the Northern Ireland Protocol, and to make sure that NI businesses have unfettered access to GB. And this is what we're doing. We now have around 39,000 businesses registered, 59% of which are GB-based businesses, with around 35% of the registrations occurring since the 1st of January, which I think demonstrates the market recognises that TSS is working and is responding. We've seen around 1.9 million declarations raised, enabling the movement of over, nearly 800,000 goods consignments. And this number increases week on week, a steady increase. So TSS is enabling the flow of goods into Northern Ireland on a daily and weekly basis. We recognise, obviously, that the rules are new and that TSS is a new service to implement those rules. And we've worked hard to educate and support traders in both GB and NI. To date, we've made over 100,000 outbound calls to provide direct support to businesses, with around double, which is around double the number of calls we've actually received. So it shows the efforts we're making to ensure that businesses are able to get on with trading. Senior members of our team conducted over 85 seminars and held over 250 engagements with businesses and trade bodies. Those trade bodies combined representing over 5,000 businesses and organisations. We've created over 30 user guides, which have been downloaded 366,000 times from our Northern Ireland Customs and Trade Academy website. Our role is to support business in how they use the service and make it as simple as possible. As traders become more used to utilising the service, and as we implement further improvements, we expect to see further ease of use and improvements in how traders interact with the service. Already, most trader interactions with the service are digital. So 85% of those interactions coming via the website and being processed online in under 15 minutes. We're not complacent. We listen to traders and adapt to the experience of their live service, providing simplifications and guidance to support the flow of goods, as is demonstrated by our consignment first model for groupage and our transit service. TSS is an evolving service, so it was stood up in an incredibly short space of time, and we are regularly releasing greater functionality to expand and improve the service that we provide to traders. We've shared a background note with the committee in advance of this session, which includes some trader experiences, together with feedback provided by users of the service. And I look forward to answering the committee's questions and providing further details. Thank you.
Thanks very much indeed. I'll just have two short questions, and I know time's moving on, but first of all, how much does it cost?
So the cost, so the HMRC have procured the overall service from the Fujitsu-led consortium. It is a publicly available figure, which is £240 million. That's for a 2-year contract. HMRC have the option to extend that contract by a further 2 years. Okay.
And how many people do you employ doing all this?
So currently around 900 people. So 600, over 600 of those are contact centre agents, various different tiers of experience within the contact centre. The rest are people engaged with the continued development of the programme, the service management, and various other personnel from across the consortium. Okay.
So I would be correct in saying that since the startup costs and everything involved, since sort of the protocols come into place, it's already cost UK PLC around about 120 million, and it's likely to cost 240 million over the first 2 years.
240 million for the stand up of the service and the run of the service for 2 years.
Okay, thanks. Okay, Matthew.
Thank you very much.
Sorry, excuse me a second.
Sorry, you want to let the other panel members?
Oh, sorry.
Oh, yes.
Oh, sorry. Apologies. It's been one of those days. Shankar, Robert, do you want to come in?
Yeah, thank you very much, Chairman. I'm Shankar Singham. I am a senior advisor on the Trader Support Service. I lead the customs and trade policy area with Trader Support Service. My background is very much as an international trade and customs regulatory competition lawyer and with an economics background as well. I have in the past headed up the international trade practices of 2 large global law firms and bring that expertise to the TSS. I've been involved in issues related to the Irish border and to the resolution of issues around Brexit and Northern Ireland for a number of years now, starting off with work on various attempts to find a solution to the Irish border, a paper I wrote in 2017, going through an agreement that I proposed at the end of 2017, the Malthouse Compromise, which included a number of members of Parliament to try to find a solution to the Irish border, including Nicky Morgan and led by Kit Malthouse. And most recently with the Alternative Arrangements Commission, where I chaired the technical panel. And I and a team put together a proposal for alternative arrangements to the then Northern Ireland backstop. That work was led on a parliamentary basis by Greg Hands and Nicky Morgan. When TSS was established, and we brought together leading experts on TSS in order to give it the best chance of success. I speak here both in the TSS capacity and also in my sort of independent trade expert capacity, and looking forward to your questions.
Okay, thanks very much, Eddie. Robert and Sam. Robert, please.
I think Robert is muted and speaking, so I'm happy for Robert to go first.
I'm still going to go first, Sam.
Go for it.
My name is Robert Hardy, and Sam's still spotlighted, but it's definitely me. My name's Robert Hardy. I'm a former freight director of P&O Ferries. Until 2017, I also ran I didn't also at the same time, but I ran the customs freight terminal at the Port of Dover, working on behalf of a company based in Newry, would you believe? So I'm no stranger to the Northern Ireland shores. In 2019, we formed the Customs Clearance Consortium, which was a specialist consortium built up to cater for the additional volume of customs declarations created by Brexit. The consortium is not actually, as it might sound, a consortium of customs clearance agents, but rather a consortium of logistics companies and traders who recognise that they would require customs formalities to be completed. And those include some very significant food logistics and general logistics operators based in Northern Ireland. I could list them, but it's probably inappropriate, and also some Northern Ireland-based traders. We like to think we're at the forefront of customs planning and customs processes. To that end, we were actually part of the design team, and we are the customs intermediary engine underneath the Trader Support Service. So we help to design those flows to facilitate the smooth movement of goods under the protocol. So we are kind of ganging up on Sam at the moment, so I'm sorry, Sam. I speak, though, as a speaker of, as a founder of the Customs Clearance Consortium, as a user of Trader Support Service, as also a user of the Traces system for the SPS controls, and hats off to DERA for the work they're doing. They are walking the tightrope between compliance and practicality very well. And also as a representative of the CCC members, the Customs Clearance Consortium members, who are based in Northern Ireland. I'll keep it short and sweet, but there was actually a comment earlier on about what's good about it almost. There's been quite a major success recently for secured by the RHA, the Road Haulage Association, only really possible because of the protocol. And in a nutshell, what is one of the benefits of the protocol? Well, to the logistics industry, it's actually cheaper fuel, which is rather a large win, to be fair. There is an essential user rebate in Europe for which is significant. It's 25 euro cents per litre in Belgium, for example, but you must be a member of the EU to qualify for this. The EU is allowed, although Northern Ireland clearly isn't a member of the EU, but because of their special status, they are allowing Northern Ireland-based transport companies to continue to benefit from that rebate, whereas GB-registered trucks cannot. And that's me.
Hurrah.
Oh, one more thing, sorry. Just in an attempt to win friends and influence people, I wish you all happy World Parliament Day.
Thank you. Okay, team. Matthew?
Thank you, Sam. I think.
Oh, sorry, Sam. Sorry, Sam.
Thank you, and thank you, Chair, and thank you for inviting me. I speak as the one member of this panel not involved
right.
with the CSS, but so I'm going to try and, in my introduction, draw on maybe some of the themes that we've heard through the panel before, and also maybe expand the remit of the discussion slightly if people wish to go there. And I think it's important to remember the fundamental starting point, which is that the UK has left the European Union, and that is inclusive of Northern Ireland. Northern Ireland has left the European Union. What we are discussing is the ongoing relationship between the UK as a whole with the European Union, but in this respect, Northern Ireland's specific circumstances. And the context here is that the British government decided to extricate Great Britain from the EU's customs and regulatory sphere, whilst leaving Northern Ireland partially within it, particularly in respect of the movement of goods. And here the political context is that the British government prioritised regulatory flexibility and trade flexibility for Great Britain over the economic coherence of the United Kingdom, and decided in favour of controls on checks on goods entering Northern Ireland from Great Britain as a compromise to avoid those controls and checks having to take place between Northern Ireland and Ireland. So my view looking at this now is, okay, so how do we make this work? And I have my preferences, and then I have what I think is perhaps realistic given the political circumstances. If we take, for example, the movement of products of animal origin from Great Britain to Northern Ireland, my preference would be to prioritise the regulatory uniformity of the United Kingdom over Great Britain's flexibility to diverge in this space, and bring Great Britain back into alignment with Northern Ireland via a Swiss-style veterinary SPS agreement. And this would not only benefit companies moving goods from Great Britain to Northern Ireland, but also food companies exporting from the UK to the EU in general. However, I appreciate that the British government does not share my view on this. It does want to prioritise this flexibility for Great Britain over the economic uniformity of the United Kingdom. So given that, Do I think that there are other options available? Yes. I think what the UK has proposed in terms of equivalence could help reduce the levels of inspection on products of animal origin entering Northern Ireland from Great Britain quite substantially. And I also think proposed trusted trader schemes could help when it comes to allowing restricted goods such as processed meat being sold in Northern Ireland. That could allow that to happen. I mean, if we look at how the grace period actually functions, insofar as if you are sending, say, chilled sausages from Great Britain to Northern Ireland, you have to raise an export health certificate. It can only happen if it's going to be sold in a supermarket. It's subject to checks. We already sort of have an audited system that I think could just be made permanent in that respect. So I'm very willing to look at compromises. I just want to help where I can. One thing I would like to raise, and this is something I raised in my written submission, and it's something that's under-discussed, is the impact of the Northern Ireland Protocol on Northern Ireland's trade with the rest of the world. So I'm not talking about the EU or Great Britain here, I'm talking with Australia, New Zealand, the US, whoever. And here I think the impact of Article 5 and also the joint declaration by the committee it's quite interesting, because from an export perspective, Northern Ireland is very much covered by UK trade agreements, and I would actually argue that Northern Ireland exporters potentially in some instances have an advantage over Irish-based exporters, because the UK rollover agreements in some cases are more accommodating than the original EU agreements, particularly when it comes to rules of origin and something called extended accumulation. They allow for EU originating components to be counted as British for the purpose of, say, qualifying for the UK-South Korea trade agreement. So it might in some instances make more sense to export from Northern Ireland than the EU, because if you export from the EU, you can't account for UK inputs in the same way. But when it comes to imports, that's where it gets slightly tricky. I would say Northern Ireland's ability to benefit from UK free trade agreements becomes more conditional, in that the UK applied tariff can only be used by Northern Ireland-based importers if A, you fulfil the not at risk criteria, but also B, you can demonstrate that the tariff applied under the UK regime is under or 3 percentage points. The difference between the EU's applied regime and the UK's applied regime is no greater than 3 percentage points. And in practice, this means that for new agreements such as UK-Australia, where there isn't an EU equivalent agreement as a reference point, you are going to get circumstances where certain imports into Northern Ireland won't qualify for the UK's free trade agreements, whereas they would if they were imported into Great Britain. I'm thinking particularly of food. But there's and you can argue this from both directions. So potentially Northern Ireland-based consumers will lose out if they're not able to access Australian products, for example, more cheaply, unlike their Great British neighbours. But I suppose there's a producer side to this argument, which is, if you approach this very cynically, and I don't advocate this, but Northern Ireland farmers, for example, will be able to benefit from UK free trade agreements, whereas not being exposed to competition from those countries, at least within the Northern Ireland market. However, I would acknowledge that they might face increased competition when selling into Great Britain. There's also an issue to do with TRQs that needs to be resolved, so tariff rate quotas. These are allowances for certain quantities of goods to enter the UK at a certain tariff rate. So, for example, X tons of lamb from New Zealand can enter at 0 tariffs, and then if a greater amount than that specific tonnage is imported over the course of a year, a much higher tariff applies. And there is currently some confusion as to how this works in Northern Ireland, because going back to the point I made about the difference between the UK applied tariff and the EU applied tariff having to be no more than 3 percentage points for the importer in Northern Ireland to use the UK regimes, we have an issue in that EU tariff rate quotas do not apply in Northern Ireland. So the reference point for a UK importer importing under a Northern Ireland-based importer importing under a UK TRQ, the reference point for them would be the EU's MFN tariff, not the EU's in-quota tariff if there is an equivalent quota, because those quotas don't apply in Northern Ireland. So it de facto means that importers into Northern Ireland can't use the UK's TRQs, which are included both in trade agreements but also on an MFN basis under the UK's WTO commitments. This is something I feel can be resolved, and the UK is trying to resolve, and I've written what I think the solution to this is in the written statement, but I'm happy to go into it further. And I will leave it there, having broadened out the discussion, but appreciating that we might be going right back into the nitty-gritty of the TSS.
Okay, thanks very much indeed. Now, Matthew.
Thank you very much, Chair, and thank you all for your evidence and coming today. I could just turn to some of the TSS representatives today. You give us a little bit of a flavour of it, but would it be correct to say that clearly the protocol is Brexit creates a range of disruptions. The protocol is a novel set of arrangements and involved new familiarisation and with new kinds of bureaucracy for people, particularly importing goods, moving goods from Great Britain to Northern Ireland. But would you say that in general the familiarisation has led to there has been a clear process of familiarisation since January with participants in the TSS? So that's to anyone from TSS.
Thank you. Yeah, so I'll take that first of all. So yes, the protocol has introduced administration that wasn't there previously. Yes, TSS has been up and running since the 1st of January, and I think from the data that we're seeing and also the qualitative feedback that we're receiving from traders, yes, we can say with some confidence that traders are becoming more familiar with how to operate and how to operate the service. We can see that, for instance, in the reduction of calls we're receiving to the contact centre. We can also see that in the gradual uptick of the customer satisfaction rates that we record for both the digital interactions and the telephone interactions as well. And we can also see it in some of the qualitative feedback and very positive feedback that actually we receive every week from traders thanking us for the assistance we're providing. Some of which of that feedback we have provided in our written submission.
How could you just, for the purposes of the record, by how much have the calls fallen since January?
So not by a huge amount, but yeah, I'd have to dig out the precise numbers, and I can supply that afterwards. But okay. I was looking at the trend lines earlier, and the number of calls has reduced. The number of inbound calls, that is. What we've done, because of as we've seen that reduction, is we've increased the number of outbound calls that we're doing. So where we see that a trader has maybe got partway through a declarations process, or perhaps hasn't raised any supplementary declarations yet, then we proactively call out to those traders to offer assistance and see how we can help them go through that administration. So yeah, a gradual decline in the number of calls, and as I say, a gradual uptick in the customer satisfaction rates. As we introduce greater functionality, sometimes that can result in a small drop-off in customer satisfaction as people get used to the new processes, but then we again see that gradual rise happening again. But as I said, more than happy to supply some more detailed numbers on the call statistics.
That would be helpful. On the point about familiarisation at the GB side, have you seen any change there? Clearly one of the issues that businesses had faced is around their suppliers not being fully aware of the provisions of the protocol. Have you seen any change in that regard?
Yeah, so the outreach we do is to GB traders just as much as NI traders. 58% of registered users of TSS are traders based in GB. and this is very much and has been a focus of ours to focus on those traders based in GB equally as much as the traders in NI, and especially the small and medium-sized traders in Northern Ireland.
And you've seen a positive improvement there in terms of awareness and familiarisation.
Yeah, positive improvements right across the board, and further evidence is, yes, we've had over 330,000 downloads of user guides from the NICTA website. Over time, we're seeing the downloads drop off as people become more used to the processes and become more comfortable with what they're required to undertake in terms of administration.
That's really helpful. If I could turn now to Sam primarily, although others feel free to answer if you have, if you wish to. You may not have seen Sam, but in the last, and indeed for the benefit of the committee, in the last half an hour, the Commission has published a press release and clarity on movement on several solutions, including on obviously on chilled meats, this had been identified, but also guide dogs green card, which is a north-south services issue, and specifically on medicines, and says that there will be a legislative proposal in the early autumn in order to make this work in time. So I just wanted to ask Sam, I wouldn't ask you, Sam, obviously to comment in detail on something that's developed while you've been with us, but do you think that, I suppose, what would be your comment on how the process has gone so far in terms of establishing solutions to practical issues on the protocol?
It's a slightly political question.
Feel free to answer it in an apolitical way.
No, that's fine, I can. Insofar as I think that the UK and the EU would have got much further, much more quickly on this if there was a greater degree of trust and goodwill between the two parties. And I think both the EU and the UK have contributed to that lack of trust. But I also, and this is just a personal view, think one of the issues is that many of the solutions to some of the issues being faced by traders trading from GB to NI might require tweaks or changes to the full trading relationship and the full UK-EU relationship. And those changes at times require the person who negotiated it to acknowledge that some of his priorities were skewed. And it's always difficult for someone who's negotiated an agreement to effectively implement it, because when you're implementing it, you notice problems, and you have to decide whether to acknowledge those problems and acknowledge that you made a mistake in the first instance or not. But when it comes to the specifics of this extension, as you said, I haven't read the detail, although I have seen during the first the announcements. I think that's something that is positive. We've managed to avoid unilateral measures. It has been done jointly, and this does point to a warming of the relationship. I do think solutions exist in this space. So in medicines in particular, the EU has indicated it is willing to change its own regulations to allow for GB authorised medicines to be distributed in Northern Ireland. That's not something that's easy to do, but I think they do acknowledge that the protocol very much leaves Northern Ireland, the delivery of health services and the like in Northern Ireland in the hands of the UK, and they can see a legal hook by which to do it. I know they are finding it much more difficult to find a permanent solution on sanitary and phytosanitary issues, because again, that would require regulatory change in the EU, and there is less of a hook by which to do it. But if in the absence of permanent solutions, I am very much in favour of can kicking for the meantime, but I do appreciate that that doesn't help when it comes to business certainty.
Okay. Yeah, I mean, agreed in terms of certainty. Just a question about the totality of the economic relationship between the EU, you're a trade expert, and not just trade in goods. It has been said that the protocol represents a fundamentally Northern Ireland moving closer to the rest of Ireland, the Republic of Ireland, in economic terms. Would it be fair to say that the provision of Brexit, that the meaning of Brexit is that in a range of areas I'm not asking you to make a political comment, Sam, but
I wouldn't permit you to either.
I think it's relatively factual, but that Northern Ireland, I mean, in terms of the other aspects of the single market that are not about the movement of goods, that we are in a sense moving further away from both the Republic of Ireland and indeed the rest of the EU. So would that be a fair statement that while we're regulated for goods by the EU single market, or partially by the EU single market when it comes to, for example, free movement of people, for example, provision of cross-border services, we're moving further away from the EU, not closer?
Yes, so Northern Ireland has left the EU just like the rest of the United Kingdom. It's just in respect of goods, this has remained within, or at least de facto within, for the most part, the EU single market for goods, and also in a way within its customs territory, although that gets complicated because it's a very conditional answer. But in other areas, when it comes to services, the Northern Ireland is like the rest of the United Kingdom. So if we think about financial services, Northern Irish firms have lost the ability to passport into the rest of the EU. If we think about issues around data, the data adequacy arrangements that have been signed off by the EU this week are incredibly important, not just for Great Britain, but also for companies in Northern Ireland, and perhaps more acutely in Northern Ireland because of the amount of data that is shared between Northern Ireland and Ireland. So yes, whilst convergence does remain in this one space, in lots of other areas, new barriers have arisen. And there are some caveats to this. If you look at the cabotage provisions in the trade and cooperation agreements, there's some island-specific arrangements to allow for an additional stop within Ireland to take into account Northern Ireland, the land border and proximity. But for the most part, Northern Ireland is in these other areas treated the same as the rest of the United Kingdom, which has economic consequences, of course.
Okay, thank you. I'll turn over now. Thanks, Chair.
Okay, thanks. Alicia. Oh, sorry. Shankar, do you want to come in there?
Well, I was just going to come in on some points that Christian was making, just to give you a sense of the interaction between the TSS and the and our customers, and also to answer Matthew's first question about the GB suppliers and the role of GB suppliers in this. I should point out that 59% of our 39 or so thousand registered traders are GB entities. So we do have a lot of GB suppliers on our TSS database. We distribute a bulletin that explains a lot of the processes every week, and that goes to all those traders. We do regular sessions with CETA and other trade associations that are associations of GB suppliers. So we do a lot of outreach work with GB suppliers as the first point. And secondly, what we also see in TSS is that when we're an evolving service, we're constantly issuing new releases, new functionality to support traders as they move products from GB to Northern Ireland. And what we generally see is as new functionality goes in, we get more questions. And then traders understand the new process and questions tail off. And we tend to see that sort of dynamic, on a pretty regular basis. We did design a process that was based on a simplified frontier declaration to get you across the boundary as easily as possible. So we didn't have headlines like "truck stopped," outside Liverpool or any of that. And that does require a supplementary declaration, and it has been difficult for traders to understand the requirements of the supplementary declaration. Most of the outbound calls that Christian referred to are in fact about getting the supplementary declarations situation sorted out for traders, and we've introduced a lot of new functionality. We constantly do, such as our supplementary declaration assistant, other things that we're introducing to make life as easy as possible for traders, consistent with the legal requirements. And I would say at the outset, the job of TSS. There are three things that the protocol is trying to do. It's trying to make sure, obviously, there's no infrastructure between Ireland and Northern Ireland. It's trying to make sure there's unfettered access from NI to GB. And it's trying to make sure there's as free flow as possible from GB to NI. And the TSS pieces of this are as free flow as possible GB NI and unfettered access NI to GB. So we continue to develop new ways of doing that. and we continue to work with the protocol, obviously, to deliver it, including using things like the Supplementary Declaration Assistant, using the UK Trader Scheme, which differentiates the not at-risk category from the at-risk category, so that for not at-risk traders, where you're trading entirely within the UK customs territory, you're able to do that in an expedited and facilitated way as possible.
Okay. Okay, team. We're sort of becoming a bit time compressed as we are at the moment because we've got some other sort of events coming up. So if I can ask Malaysia, and sort of apologies, but asking you for a fairly short question, please.
Yes, Fadger Oldlings, all very welcome here this evening. The TSS, we actually receive a lot of criticism from businesses and that as well too, to the point that where they say that it's not fit for purpose. How do you respond to that?
Yes, thank you for the question. We have heard that criticism, which I think was a number of months ago now, and I would say in response that the evidence we're seeing from the traders that we are interacting with on the service on a day-to-day basis is that the service is helpful, is usable, is helping them to process their paperwork and undertake the administration they now need to undertake. As I said earlier, we receive a lot of positive feedback every week. We've given some of that examples of some of those in the written statement. Yes, I accept that some traders have had challenges. And when we have seen that happening, we have proactively reached out to those traders to help them. Once we have provided that assistance, then inevitably we get really good feedback and we get thanks for the help that's been offered. We have in the contact centre, as I said, we have 620 agents. The majority of those agents have more than 2 years of customs experience. Those are our Tier 2 agents, and our Tier 3 agents actually, between them, have more than, actually, each of them has more than 7 years of customs experience, some of them over 20 years. And it's those where we see traders having specific challenges or problems, then we escalate up through those tiers of agents so that we provide the most appropriate expert resource to help those traders. So I'd say in response to your question, yes, there has been feedback as you intimated. I think that feedback from what I heard was from a few months ago, and I think if we look at the statistics and the feedback receiving now from the traders, the system is providing for their needs. As Shankar said as well, it's very much an evolving service. So every 6 weeks or so, we provide new releases which further enhance the user experience and make it easier for the traders to undertake that administration.
Okay.
Just in addition, I think it was Sam who also commented on the lack of trust between the UK and EU. Do you think that in some respect underpin the difficulty they have in receiving data or sharing import data with each other? This was an issue that was actually flagged up by Sokovic this week as an outstanding problem.
So my understanding of this, and I'm sure others could add into this, is it's actually more of an issue of the UK overcommitting and being unable to provide that data in the required time, rather than a reluctance to provide it, insofar as they've had to create a new system, they've had to pull stuff out from elsewhere, and they just haven't got it all compiled. My belief is that we will see that data shared in the coming months. And I would hope that wasn't just a negotiating gambit, and I've been led to believe it isn't.
Okay.
But has the failure to provide that data helped contribute to the lack of trust? Of course it has, because it's something the UK committed to do and then didn't do. And you know, and you've all lived the arguments of the last few months, so you know it well.
Okay, thank you. Thank you, Malaysia. Sorry, just go ahead. Jim?
2 questions, if I might.
Short ones, please.
Yes. So we have a trader support service with 900 staff. We've had almost 2 million declarations, all related to internal UK trade from GB to this supposed part of the United Kingdom. Could someone explain to me how that is reconcilable with the supposed assurance in Section 46 of the Internal Market Act of the free flow of goods between Great Britain and Northern Ireland?
So if I can take that initially from a TSS perspective. First of all, I'd say that what the protocol does, and I come back to the statement that both Christian and I made at the outset, which is that the job of the TSS is to deliver, and the job of the protocol basically is to deliver as free flow as possible, GBNI, not free flow, as free flow as possible. Requires us. There are customs procedures because the European UCC, the customs rules apply, but the issue with the protocol is that Northern Ireland is de jure in the UK customs territory, and de facto applies the rules of the European customs, the UCC, and that creates a very unusual situation. It's a special status. It's akin to a special economic zone in a way, and administering those processes is what TSS does. Therefore, you have a very different situation for goods that are moving from GB to NI not at risk than you have from goods that are moving from GB to NI on an at-risk basis. And there is much more flexibility and scope for facilitations in that area than not at-risk area. And that's what we're seeking to capitalise on, to lower the volume of trade. So that's how TSS is looking at this issue.
The other question I wanted to ask, last week we had evidence that much of this protocol inhibition in trade could be dealt with if you had a system of mutual enforcement. In other words, Northern Ireland authorities would enforce EU rules on anything exporting into the Republic, and vice versa, the Republic would enforce UK rules on goods coming the other way. Could I ask Mr. Shanker, isn't that a far simpler, more viable proposition than the complexities and the constitutional upset of the protocol?
Well, I think it depends what you mean by mutual enforcement, and I'm aware of this idea. And in fact, I'm very aware of it because it was in it's one of the many things that was suggested in the alternative arrangements work that I was involved in. The problem that I see with the proposal is it doesn't solve a number of the key problems which actually do cause all the difficulty that traders have. So, for example, you would still require a customs database, you would still require customs processes, you would still require an equivalent of the TSS, albeit if you're operating across the NI Ireland border, you would still require that customs database to deal with those kinds of traders. It would be a different group of traders, but it would be a group of traders. And even in alternative arrangements, we could not see how you would avoid an SPS regime over the island of Ireland, at least. And since many of the issues are related to SPS controls and checks, we don't see that would really make it much of a meaningful difference. It also, frankly, requires a level of trust between the parties that are operating it. But sort of, you see a little bit of this on the Norway-Sweden border, where there's obviously a high degree of trust. You see some regulatory recognition, not mutual enforcement of processes, but some regulatory recognition between, let's say, Australia and New Zealand, where there's a lot of trust, and trust has to get built up over time. So while I certainly, I still stand by the work that we did in alternative arrangements, that was at a particular point in time. We're at a different point in time now, and my concern with this is I think we are moving towards lowering the concerns of traders. I think our goal is to make the process that traders have to experience at the NI-GB boundary more like administration and less like a sort of full-fledged customs regulatory process.
But it certainly would put the border where it should be, at the frontier, instead of partitioning the United Kingdom.
Yeah, so I think if you look at the boundary between NIGB as it's being implemented at the moment, it is. I mean, Northern Ireland is, without question, does have a special status under this arrangement. There is no doubt that it has a special status. There are aspects of the boundary that have processes that you would not normally see in a customs within a customs territory. But on the other hand, there are also aspects of it that you wouldn't see between one customs territory and another customs territory. So, for example, the whole not at risk category, the UK trader scheme, which covers a significant volume and value of trade. You wouldn't see that in between two customs territories. So it's got multiple aspects to it. And the question, I think, really is, can you make it as facilitated as possible? If you can't make it as facilitated as possible, if it cannot be reduced to something that looks a bit more like an administrative process, then yes, it is a burden. But our perspective in TSS from the 6 months that we've been operating is we've seen a reduction in that burden on traders, and the proof of the pudding actually is in the trade data statistics. So if you look at GB to NI movements, and this is something that perhaps Mr. Harley can comment on, you actually see the trade data for GB NI direct movements going up compared to last year. So despite COVID, the trade statistics suggest that GBNI trade has increased, and TSS is sort of administering that trade, and that suggests that it can be achievable. Whereas, by contrast, GB to Ireland trade, certainly over the central corridor, like Holyhead, Dublin, has gone down significantly after January 1, 2021. So something is happening on that boundary that's better for traders, that is improving for traders. And the question I think we will I'll sort of need to answer is that a trajectory that can get us to a point where we get to at that point as free flow as possible, or is that not possible? And that's a question for others. But I think Mr. Harley probably has some good statistics on how those two things have.
Yeah, if you don't mind me jumping in, thanks, Schenker. Schenker's absolutely right. The growth, every ferry route is down, apart from the new ferry routes, of course, from sort of Zeebrugge to Dublin or what have you, because they're completely new. But every other established ferry route has seen a reduction in traffic in the first 6 months of this year, apart from Northern Ireland. Northern Ireland has seen a year-on-year growth of 20%, whereas Dover is suffering because of the volume of traffic. The central corridor of the Irish Sea is suffering because of volume of traffic, and yet this continued growth. And going back to the previous question is that why should there be so many customs entries on consignments that are purely for internal trade? The point is that they're not, and you need to be able to identify which ones are for internal trade and which ones are not. And that equally works for Northern Ireland flows via Dublin, is that there needs to be, if you start to put more regulatory controls on the island of Ireland, it's going to be harder for a logistics operator in the north to ship out through the south, because there would be more controls than there are today. It's a much easier process today. So the issue with Brexit generally is you've gone from a situation where goods that flowed previously freely and on the basis of the goods being innocent unless proven guilty, they're now almost guilty unless proven innocent. And the customs declaration is the document that gives more information about that. I think that where Schenker and Christian have been completely right is that although there is more administrative burden, there hasn't been any significant delay to the movement of goods, and that's proved by the fact that the Ken-Ryan-Larne routes and Ken-Ryan-Belfast routes have seen a 20% growth when everybody else has seen a reduction in traffic.
I think you should talk to some of my constituents who've had trailers stuck at Larne Port, and you take a very different view, sir.
No, they may be SPS. There may be SPS controls. It's very unlikely to be the customs element. And the SPS, look, I think the UK Trader Scheme has a position. Greater use of the UK Trader Scheme has a position as a point to play here. But I agree, I've had trucks stuck at Belfast and at Larne in Dunkery Street for the wrong paperwork. It's always SPS. It's always SPS controls, and they are the most cumbersome.
Okay.
And I think there is an opportunity to continue to simplify and facilitate and to use the UK trader scheme. And so to come back to your question on mutual enforcement, I think the better approach is to say, well, let's use the UK trader scheme, let's use the not at risk category to determine, because obviously with regard to SPS, there's no doubt that under the protocol, the European rules, the European SPS rules apply, and you need to comply with the European SPS rules. But the evidence that you need to provide to show compliance and the way you adduce that evidence, there is a difference between the not at risk category and the at risk category. And I think if we explore that a bit more, we'll be able to deal with some of the SPS restrictions and difficulties as well. And certainly there are a number of things that we can do, simplifications, facilitations, that are fully UCC compliant, trusted trader schemes, periodic declarations, aggregation. There's a lot of things that we can do that lower the impediments and the barriers. And I think, TSS is working to introduce a lot of that functionality, so that, depending on what the EU and the UK ultimately agree, we can actually support all of those movements.
Okay, thanks very much indeed, Shanker, for that. Pat?
Thanks, Chair, and thank you as well. I want to talk just quickly on the Trader Support Service. It's very small. I've not told you back very long. I've looked down, and people have come back to me to say they're very impressed with the rollout. I'm looking there at 90% of declarations successfully processed in less than 15 minutes. Now, during this pandemic, I have to say well done, and I know a lot of your staff are working at home as well. But you see the 10% that weren't processed in that 15 minutes. With your education and your engagement and your trader preparedness that you are working through, is that 10% marginalising now? That's taking it in from the 21st, of January. But if you look at it now, it must be significantly less than 10% on a week-by-week basis of those that are not being successful or processed within the 15 minutes. That's the first part of the question. It really was for Christian.
So I apologise, but I found that I only caught part of that question.
Okay,
there was a break-up in the sound, so,
right, so more than
it might be on my side.
90% of the declarations are successfully processed in less than 15 minutes. So that leaves 10%. The main part of the question was, that was 10% from the 21st of January. But if we look at it where you are now, surely with your educational system, your engagement and your trader preparedness that you have there, this number must be coming down. It's not nowhere near 10% now. And I want to commend your staff for working through this pandemic, because they are very impressive set of results there that I've read there today.
Yes. So yeah. Thank you very much. And we are seeing we are seeing those submission times and those processing times come down all the time. I mean, the majority of declarations that are submitted, if the information is correct, if the documentation is correct, are submitted almost instantaneously over to HMRC, to the CDS system. It's fair to say that when we introduced supplementary declarations, we saw that more traders needed more assistance, which we supplied, and also that some traders were struggling with the information that they needed to provide. So, but over time, and over the last few weeks especially, we've seen the right first time rate increase dramatically as we've improved the education, as traders have got used to using the service, and as we've introduced more enhancements to the service that make it more difficult for the traders to make mistakes. But yes, thank you. I very much appreciate your comments, and I will pass that on to the members of the service.
Thank you. Well done. And the other one was for Sam. If you could explain to me, maybe I missed, I don't know if the rest of the committee members were aware of the 25-cent refund. Did I hear that right? On fuel from Northern Ireland if the hauliers are going into the European market?
That was me, actually. I'm going to take the credit for that one, if you don't mind. Sorry, Sam. There has always been in Europe an essential user rebate on fuel. Used to be known as the TIPP, professional diesel, professional petroleum, basically. And we used to handle a lot of these claims for hauliers based in Northern Ireland and in mainland GB. Of course, when Brexit finished, we're no longer part of the EU, and you had to be part of the EU in order to be eligible for this rebate, which is 25 cents in Belgium. I think it's about 16 cents a litre. This is this is 70 or 80 pounds per full tank of fuel, you know? So these are not small figures. And in France, I think it's about 16 cents a litre, but you had to be registered in the EU, and of course that disappeared on the 1st of January. If I believe what the RHA are telling me, it's not quite over the line yet, but the RHA have done some great work in lobbying for the NI operators to keep this, and to all accounts they've won. They've got approval on it, which is a fabulous advantage. Look, I would expect to see a lot of transport companies. In fact, I ran a poll on LinkedIn the other day, and it was quite positive that there'll be a lot of transport companies in GB who will now flag out to NI. So expect to see a lot more Northern Ireland hauliers.
Yeah. So that's really 20%. I mean, that's a really strong advantage, and it shows the potential of where we are. I'm trying to look at all of the positives coming out of here today. So
you got a declaration of interest. You own a haulage company?
No. But I can tell you, 20% is good. I mean, that must give our hauliers here in Northern Ireland a really strong advantage of nearly 20% on their fuel costs, like across Belgium, and 16% in France.
I should have picked up when you turned that to percentages that you know more than just the cost of fuel for a truck. But look, it is an advantage. And it's only available because of the unique situation of the protocol.
Yes.
Well, I think.
Well done. I have to commend that. Then that's great news to me.
I can say categorically, Pat, that for once now I recognise that somewhere, even the teeny slightest way, I've heard for the first time some benefit in this protocol.
Well, I wanted to bring it out to show it to you, Chair. I'm always good to educate and learn.
Right, on that note, thank you very much indeed, gentlemen. Thank you very much indeed, Christian, Shanker, Robert and Sam. Thank you very much indeed for your evidence. Thank you very much indeed for coming through. And thank you very much indeed for sort of providing the written evidence as we've come through. But sort of have a good rest of the day. You've probably seen us sort of beavering away behind the scenes and the rest of it, but the European Union statement's just come out this afternoon. So some of us have been trying to have a look at that to see whether I still need my dog to get vaccinated against non-existent diseases like rabies. But that's not a political comment, that's a veterinary comment. Okay, thank you very much indeed, team. Thank you. Cheers. Thank you, Robert.
Thank you very much.
Thank you. Team, for what we're on, we just need to stay correct, but we've got a couple of bits and pieces that we need to do. I will try and accelerate them through. Item number... Okay, right, sorry. Item number 8 in the agenda, written briefing, retention and disposal. The retention and disposal schedule for the Department of Finance was led in the Business Office under Section 8.2 of the Public Records Act, and in accordance with the rules of the Disposal of Documents Order 1925 by the Public Record Office Northern Ireland, a copy is at page 142. These schedules are subject to negative resolution procedure. This means that if the committee or any members objects to the disposal of any document on the schedule, it can pray against it. This is done by submitting a motion for plenary debate to require preservation for any scheduled records. If no motion to preserve is made within the statutory period, the scheduled disposals will be implemented. The statutory period expires on the 21st of September 21. I hate to be a pain, but if you look at 153 on your papers, you will notice that for the issues of health and safety and claims and fire safety records and inspections, the department are considering a retention period of 5 years and then destroying the papers. There is also an issue when it comes to premises on acquisitions at 7 years and destroying the records. I've got some problems with that, bearing in mind trying to keep on top of what's going on, particularly with the procurement issues, and indeed I'm looking particularly at my two members from the party who hold the infrastructure minister. If that indeed was the case, some of the issues that were being dealt with at the moment, and she was in the Assembly discussing, particularly to do with procurement contracts, some of those records would have gone. I have concerns about the timescales of that, and I think I would like to get some further information about how those compare with other government departments across these islands on those specific issues. What drew me to the attention, and I apologise, Clark, for not bringing it up earlier, but there was something about it when I was looking at health and safety records, and I thought that the retention period of 5 years was probably too short. And indeed, not only was it too short, the application to destroy them after 5 years, I think, would be something that I might have a degree of concern with. But I'm willing to be. I would rather have some advice from what happens in the rest of across the rest of these islands before we're in a position to make that situation. Are there any other comments from any other members?
No, Chair. Other than I think that's reasonable to ask for more information. I think you're right that there is a particular issue that Infrastructure Minister has highlighted, so if the request is for more information, I think that's reasonable.
Yeah, it's just, to me, when it's also about health and safety records and it's about accidents, it says retention period for 5 years. I know that I'm dealing with, as a constituency case, accidents relating to work within the Northern Ireland Civil Service that were much longer than 5 years ago, and they're having difficulties getting records, so it just concerns.
Inland Revenue requests that businesses keep them for 7.
Yeah, that's what. Again, that's you know, to me it just looked like sort of the figures seemed to be quite short. Okay, we're happy.
Right to the department in those
right
terms.
To the department in those terms. Thank
okay.
you. If we move on to item number 9, written briefing, business tenancies restriction of forfeiture. Ministerial correspondence on page 216 advising the committee of the forthcoming secondary legislation, the business tenancies coronavirus restrictions and forfeiture Northern Ireland number 2 regulations 2021. Our government announced its intentions to significantly extend statutory measures that protect commercial tenants from eviction to the 25th of March 2022, as well as announcing major plans for primary legislation for England at Westminster. That legislation will act to both ring-fence outstanding unpaid rent built up during the pandemic, as well as providing for the imposition of a compulsory and boundary statutory arbitration process for rental disputes. As the protections currently in place in Northern Ireland are due to expire, officials were instructed to make an urgent statutory rule to extend the relevant period for restrictions on forfeiture until the 30th September 2021. There will be no SL1. The SL5 will come to the committee next week. One of the questions I asked when I was briefing Peter earlier on, I would like your sort of thoughts on. It seems strange that we are looking for a restriction of forfeiture under the 30th September. So we will be coming back and immediately reconsidering it. Should we be asking the department, because we've got time to look at it again next week, should we be asking the department whether they should be pushing that time out in line with what's happening across the rest of the country? It just seems surprising that, particularly with the Minister, is looking when there's protection going out to the 25th of March 2022 in the rest of the country, and we're only taking up to the 30th September. Are you happy for us to write to the department and ask for further views on that and why they're not going to push the date further out?
Yeah.
Agreed. Okay, thank you. Moving on to correspondence. Correspondence, members are asked to note the index of 11 received items of correspondence at page 219. The members are asked to note a memorandum reply at page 222 to the Public Accounts Committee on the report Major Capital Projects. The Public Accounts Committee recommended important governance changes to the role of the head of the Civil Service as accounting officer for all departments. Members are advised that the PAC will formally consider the memorandum of reply, and then other committees will be free to scrutinise. Are we content to note? So noted. Legislative programme, item 3. Members are asked to note page 232 a response from the department on its current legislative programme. Of note is that the social value and procurement legislation is unlikely to progress in this mandate, and no timescale is provided for fire safety building regulations. I think that I would like to get some views on that, because I understand that they're saying it's because there's been a delay in the legislation coming in about from England and Wales. but are we content to get some more information about the delay in fire safety regulation, bearing in mind our concerns surrounding Sir Grenville and the evidence we've received? Are we content on that?
Agreed.
Content. Okay. Item number 4, accruing resources. Members are asked to note at page 237 a departmental response in regards to accruing resources, which advise that accruing resources which exceed levels projected in the estimates are retained in Northern Ireland. Is the committee content to note? Noted. Designation of arm's length bodies. Members are asked to also note a departmental response on page 239 regarding the different designations available to arm's length bodies. Is the committee content to note? Noted. Delay to the Northern Ireland civil pensions payments, civil service pension payments. Members are asked to also note at page 242 a further departmental update on the delay of payments to members of the civil service pension scheme in May this year. The department confirms this error was with the Northern Ireland Civil Service and not Capita, as previously indicated. Are we content to note? Noted. Okay. And I apologise to Capita for I think I added them onto the list of complaints that we had when I was speaking in front of the Minister at the Assembly the other day. I think there was about 10, so it's only 9 now. Item 10.7, invitation. Members are asked to note at page 243 an invitation from the Women's Policy Group Northern Ireland to attend the relaunch of the Women's Policy Group COVID-19 Feminist Recovery Plan on Wednesday the 20th of July from 10 a.m. to 12 p.m. via Zoom. Are we content to note? So noted. Building fire safety. Members are asked to consider at page 246 a response from the Department for Communities regarding building fire safety programme, confirming measures taken in respect of tower blocks. It is understood that the Department of Finance is back in the lead for this matter rather than the head of the Civil Service, and a further response from the Department is expected. I think we were briefed that it was being handed over to the head of the Civil Service, and now we're being told by the Department of Communities it's come back from the head of the Civil Service. I would quite like some clarity from the Department of who actually has responsibility for this issue, because I think it's important, bearing in mind the previous level of area of correspondence we're looking at. Are you content for me to write to the Department to ask that question? Thank you. And we're also content to forward to Rockwool Limited the issue about who has responsibility for building fire safety. Are we content to forward that to Rockwool Limited?
Agreed.
Great. Written statement, June monitoring. Members are asked to note on page 250 ministerial correspondence on a written statement in relation to the 2020-2021 provisional outturn and 21-22 June monitoring. The Department will brief this on the 7th of July. Are we content to note? Great. Northern Ireland Audit Office Corporate Plan. Members asked us to note on page 280 correspondence from the Northern Ireland Audit Office advising of its work in respect of the Department of Finance, providing a copy of its corporate plan. Are members content to note? Agreed. Item 10.11, increasing building regulation fees. Members are asked to consider at page 321 correspondence from the Department of a consultation plan for the summer involving a 35% increase in building regulation fees. Are members content to receive a summary of responses following the consultation? Any comments? 35% increase in building regulation fee.
35%.
Would it be useful in the final week before recess if we had a note from the department of a breakdown of why there was a 35% increase in the fees? Because I think it will be of interest not only to MLAs but many of our constituents. Are we agreed? Happy, Gemma? Happy, Militia? Yep. Yep. Agreed. Item 12, participatory budgeting. Members are asked to note at page 340 a copy of correspondence from the Committee for the Executive Office to the Department seeking its views on the use of participatory budgeting. Are members content to note?
Noted.
Note. Composite request. Members are asked to consider the composite request at page 342. Are we content to note and content the Committee's composite request is an accurate and complete record of our information requests? Are we content and agreed?
Agreed.
The forward work programme. Are we content with the forward work programme?
Yes.
Agreed. Any other business?
No.
No. Date and time of the next meeting. Sorry we sort of went on a bit, gentlemen, ladies and gentlemen, but next meeting is at 1400 in here on this next Wednesday. Thank you very much indeed. The meeting... Oh, sorry, Gemma. Sorry. Are you waving?
You're saying goodbye.
Oh, you said goodbye. Sorry. That's been all this day. Thank you very much indeed. Thank you for the session. Cheers, Malaysia. Cheers, everybody.
Thanks, members. Thank you.
Thank you.
Cheers, thanks.